And now I would like to ask my colleague Melanie Schwartz from the Faculty of Law to acknowledge the traditional owners of the land. Over to you, Mel.
Thank you, Ludmilla, and it's lovely to be here with everybody, and it's my pleasure to acknowledge country. I am here on beautiful Bidjigal land, and I know that people are joining from all different lands across Australia. This land has been kept by and has also kept our traditional custodians through history and still today. And so I wanted to acknowledge all of the elders past, present and emerging, and also, given what we're here to speak about today, to also acknowledge all of the multitude, the hundreds of languages that are also part of these lands, and all of the knowledge and wisdom that inheres in those languages. So I acknowledge country, and I acknowledge all of our Indigenous languages, and I'd like to welcome everybody here today.
Thank you very much, Mel. And now, it gives me a great pleasure to invite the Dean of our faculty, Professor Claire Annesley, to welcome you and open the symposium. Over to you, Claire.
Thank you very much, Ludmilla. Hello and welcome to this Symposium on Legal Interpreting. I'm Claire Annesley and I'm Dean of UNSW's newest faculty, the Faculty of Arts, Design and Architecture, ADA, and I'm delighted to have the opportunity to open this event today. I too would like to acknowledge the Bidjigal and the Gadigal people who are the traditional custodians of the land from which I'm joining you today, and I'd like to pay my respects to elders past, present and emerging, and extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. And welcome to you all to this impressive event, to all of you who are joining us from across the partner organisations of the ARC Linkage Research Project on which this symposium is based this year. Welcome also to the eminent members of the panel, the judges and magistrates who are joining us today. You're all very welcome, and it's wonderful to have this opportunity to bring everyone together. So this UNSW Symposium on Legal Interpreting, as we know, is hosted by the dynamic and wonderful interpreting and translation section of the School of Humanities and Languages in the Faculty of Arts, Design and Architecture. And this symposium was founded in 2011, and as you know, it's hosted annually, bringing together researchers and practitioners to share knowledge, share experience, and try to overcome some of the challenges that exist by bringing our knowledge together. And that spirit, that the way that we're bringing together knowledge with practical application is absolutely at the heart of this new faculty that we're just creating at UNSW. Our vision for the new Faculty of Arts, Design and Architecture is that through creativity, collaboration and inclusion, we solve problems to improve life on Earth. And we say that we listen, challenge, create and share diverse knowledge about people, place and cultures to enable lives with purpose. And I think that what you're doing today and the way that you're bringing together knowledge with practical application is absolutely the heart of the mission of this new faculty. So it's wonderful to see this event today. The focus today is on legal interpreting issues and the discussion of practical solutions to these current problems. And it makes such a valuable contribution by bringing together various stakeholders and also bringing together, creating that link between our students, our postgraduate students and our PhD students, bringing our students into contact with professional networks and real life research so that they start to feel like they're part of this really important profession and community. The symposium, as we said at the outset, is founded on this really important ARC linkage funded research project, the title of which is Access to Justice in Interpretive Proceedings, the Role of Judicial Officers, which is led by my wonderful colleagues Ludmilla Stern, Sandra Hale, Stephen Doherty, and Melanie Schwartz. And this is a really important project which engages the participation of interpreters, judicial officials, and the courts to improve the outcomes of interpreted communication and better access to justice for non-English speaking participants. Such an important endeavour. And this symposium is going to bring out original research, early research findings from this project with practitioners and really give a forum today for the experiences of interpreters and judicial officials, officers, so that can be shared and that can be discussed. So I think it's going to be a great afternoon, a really, really important event. I'd like to say congratulations to the organisers for bringing so many eminent people together. Welcome again to this important and impressive symposium, and thank you for joining us today.
Thank you very much, Claire, for your warm welcome. And as I said, I do hope that today's symposium is going to be valuable in more than one way. So Claire has already introduced my colleagues and team members of this research team, Professor Sandra Hale and Stephen Doherty from the School of Languages and Linguistics. Humanities and Languages, Melanie Schwartz, our colleague from the Faculty of Law, and Dr. Julie Lim, a research associate. And I am Ludmilla Stern, Professor of Interpreting from the School of Humanities and Languages. So today's symposium, I'm going to say a few words about the project and its link to today's symposium. And after that, I will talk about some of the presentations. Most of you would have seen the program, and you know that its topic revolves, but is not limited to the communication between judicial officers and interpreters. We are going to deal with broader interprofessional relations that involve lawyers, court administration, and other professionals. And we are also going to discuss how court environment and how the operation of our professionals impact on the accuracy and the quality of delivery of court interpreters. There are 4 presentations, at the end of which there will be a Q&A moderated by Stephen Doherty. There will be a 15-minute break at 20 to 3. And after that, following 2 more presentations, there will be a panel discussion moderated by Melanie Schwartz. And towards the end, Sandra Hale will provide a conclusion and recommendations. And we aim to close the symposium at about 5 o'clock. Feel free to join if you have to leave, if you have to join back in at a later stage, you are most welcome to do that. So this is roughly about today's program. Just let me remind you what our project is about. It is the first project of its own kind that aims to study the judicial officer's role in achieving effective communication during interpreted bilingual proceedings in court. This national project is funded by ARC and also by 8 partner organizations. They are key industry stakeholders. So we are looking at communication practices by judicial officers in criminal proceedings, and our aim is to establish whether judicial officers modify their practices to communicate effective, to accommodate effective interpreted communication. Furthermore, we would like to establish whether they adhere to the recommended national standards for working with interpreters and in courts and tribunals. And I'll refer to this document in future as recommended national standards. Our focus is not only on so-called established languages, but also on the so-called new and emerging and indigenous languages, where training is limited and the levels of certifications are usually not as high as for interpreters in established languages. And so we are interested to see whether judicial officers and other professionals offer additional support. So our four main questions are as follows. What are communication practices that judicial officers follow in bilingual proceedings in national and international courts? How do national judicial officers' communication practices in domestic courts compare with those in international courts and tribunals? To what extent do judicial officers adhere to the recommended national standards? And if they don't, what are the obstacles to the implementation of recommended national standards? And finally, how can barriers to access to justice in interpreted proceedings best be addressed? So this year has been a difficult one for our project as well. Our fieldwork that began with the observations of interpreted proceedings didn't entirely go according to plan because, on the account of COVID-19, we had no access to courts where we planned to conduct observations. I did manage to go to The Hague in March, where I did observations and interviews at the International Criminal Court and what used to be the tribunal for the former Yugoslavia. But that was cut short because the courts were closed again because of COVID. However, what was confirmed once again are the high standards of interpretation, excellent working conditions provided by international courts, and the enlightened way in which the judges work with interpreters. So in many ways, international courts continue to be a benchmark of the optimum working conditions for and with interpreters. Now, in New South Wales, our court observations began in mid-late August. And we observed both short and long matters, from cancellations of cases and mentions to 3-week-long trials. And our observations confirmed that judicial officers do acknowledge the fact that proceedings are interpreted and the interpreters are present. And most of them modify their communication strategies consciously or unconsciously to accommodate some of the interpreter's needs. And I will add, to some degree. Judicial officers generally tend to speak at a reasonable pace. They acknowledge interpreters' requests for a break or repetition. They instruct the witnesses to speak in shorter chunks and the parties to slow down or rephrase unclear questions. Again, this is perhaps a preliminary generalization, but this is something we could conclude on the basis of observations and interviews with interpreters. Many judicial officers, and that has also been corroborated by interpreters in their interviews, do not discourage interpreters from interrupting and addressing judicial officers with requests for repetitions and clarifications. So these and other accommodation strategies, of course, vary from one judicial officer to another. And this is something, by the way, that is also confirmed in post-observation interviews with interpreters. Now, what came as a surprise through the interviews with the judges is that mostly they are, or those whom we interviewed, are mostly unfamiliar with the recommended national standards and other policy documents on how to work with interpreters. And as they shared with us, they modify their communication strategies essentially basing these modifications on their experience and their perceptions. and I would say perhaps some misconceptions. And this came as a surprise considering the vast promotional program by JCCD after the recommended standards were published in December 2017. So, like the judges in international courts, those judges in New South Wales domestic courts whom we interviewed have not undergone training or awareness sessions or consulted scholarly studies. And often they reflect a lack of understanding about the interpreting process, which leads also to some, for example, to misconceptions about how long an interpreter can possibly interpret in the dock using simultaneous whispered mode, chuchotage. There was also the judges, some of the judges were surprised to hear that interpreters need some form of briefing or preparation. And some expressed a strong belief that requesting an interpreter is a deliberate strategy on the part of the accused, and therefore it should facilitate the, the workload imposed on an interpreter, for example, during a longer trial. So these perceptions, as we discovered from observations, are not unique to judicial officers. They're also shared by parties who may initiate the booking of an interpreter, but do not provide any information or briefing and are less considered in their speaking style than, for example, the judges. And we'll hear more about the role of preparation in one of the subsequent presentations by Vicky Wong. Now, these observations of misconceptions about interpreters' requirement are corroborated by the interpreters' interviews. And so some more experienced interpreters agreed that in the past 10 years, the treatment of interpreters in courts has improved. But they also shared their experience of poor working conditions and poor treatment of interpreters within the court administration system. And we will hear more about it from Erica Gonzalez in her presentation based on the AUSIT interpreters' voices. Finally, while present in court, we noted that the system of booking and planning of interpreter booking is often insufficiently efficient. And I suppose it's a euphemism for poor planning and wasteful practices. Short notice cancellations of interpretation booking, lack of adequate information that should be passed on to interpreters who have already arrived. One of the disturbing observations amidst the COVID requirements for masks and social distancing was a lack of consideration and provisions by the court for the social distancing between interpreters and the accused in the dock, or interpreters and the defendant in the public gallery. Not to mention a very deplorable ergonomics of seating arrangements, sometimes for many hours and days. And some of it will be reiterated by Sandra Hale in her presentation after the break. So in looking at these practices in domestic courts, one may ask why these interprofessional interactions and working conditions aren't any better, especially since the publication of the recommended national standards 3 years ago. So some answers will be suggested in our examination of policy documents on working with interpreters in courts. And this is the topic of my presentation that I am about to begin. And hopefully it will help us contextualize our research. So I will now pause, and Julie, I will ask you to, thank you for stopping the sharing. And I'm going to share a document that you will hopefully all see in a minute. And Julie, if you could tell me whether it's okay. Yeah, thanks, Stephen. Yeah, I can see. So the presentation that I'm going to share with you is about how policy documents have shaped the practices of working with interpreters in courts and tribunals. And I'll make some observations about evolution over the years and limitations. So essentially, in order to understand how the conditions in which interpreters work in courts, we have consulted a vast amount of documents, starting from about the Second World War, that discuss human rights, a right to a fair trial, and the role and the place of interpreters in criminal proceedings. And some high-level documents, as we discovered, establish the principles of non-discrimination and the right to a fair trial. For example, post-World War II international resolutions and covenants. Other documents actually start writing in the principles of working with interpreters in courts. And international courts have been the leaders in this field, also beginning with the Nuremberg and Far Eastern trials post-World War II, and also contemporary tribunals and international courts. And finally, we looked at domestic courts more recently, starting from about 1970s, 1980s, and we looked at the legislation and policy documents which write the interpreters into the policy. And that includes the provision of interpreters, the quality of interpretation, working environment, and the emerging theme of the role of court administration and interpretation users. And that's quite this theme began to be voiced much later than all the others, especially the role of the judicial officer. And this is a gap that we identified, a gap that is being filled in the 21st century, how a judicial officer can contribute to the quality of interpretation and effective interpreted communication. We also observed some of the limitations. So why some of these good practices and standards are so slow to be implemented. So as I said, the first high-level documents go back to the end of the Second World War, and they say nothing about the interpretation. They only state the principles, the human right of non-discrimination on the basis of the language rights, and provision of a free interpreter, and that's already mid-1960s. The good practice, as I was saying, began to be implemented in international courts, beginning from post-war international courts and tribunals, international military tribunals, and they mention the fact that the defendants should have the right of hearing the proceedings in the language of the defendant or the language of the accused. The different tribunals use different terms. Contemporary international courts and tribunals have developed many in-house documents of different level of hierarchy. They are UN statutes. They are in-house rules of procedure and evidence. There are manuals on developed practices, and there are codes of ethics. And all of these policy documents and in-house guidelines were developed throughout the existence of these tribunals and were based on the experience of the professionals in these tribunals. So there is a lot more information in these international courts and tribunals documents, not only about providing information promptly and in detail in the language of a person detained, but also about the free assistance of an interpreter. The Code of Ethics outlines the duties and responsibilities. The registry policy includes the provision of qualified interpreters and the provision of professional working conditions. So all of that was developed, I would say, in the mid-late 1990s onward, from the time of the creation of the tribunals that dealt with the former Yugoslavia, with the Balkan crisis, and the Rwanda. Now, and already there you can see that some of the provisions include advanced provision of speeches and guidelines for speakers, and the rights of an interpreter to interrupt, seek clarification, repetition, and so forth. So this is something that has been included in these relatively early guidelines that were developed over the subsequent years. Now, I have to say that there is very little, there is nothing specific that would guide the judges in working with interpreters in international courts. There is a little bit about sensitizing speakers, but there is virtually nothing for the speakers. There are one-page documents, sheets at the International Criminal Court and at the Special Tribunal for Lebanon. And this is more than the International Criminal Tribunal for the former Yugoslavia. So these are very specific guidelines, bullet points, but no more. Speak at a reasonable pace, speak into the microphone, and so forth. Now, let's now turn to domestic courts. And I have to say that we looked at quite a lot of jurisdictions. We looked at Canada, America, United Kingdom, European Union, and clearly I'm mindful of the time, so I will have to rush through them and say that in countries like Canada, UK, and United States, all these principles were legislated. So there are different acts about human rights acts, the Bill of Rights, and they are the ones that write the interpreter and principles of working with interpreters in it through the legislation. And in Canada, for example, these documents, these provisions are binding. In different states and provinces of Canada, for example, again, there is an obligation of certain standards of interpreting, continuity, fidelity, impartiality. So this is an obligation. These are not so much guidelines as in the Australian Code of Ethics. In the United Kingdom, again, unfortunately, I can't talk about the EU directives because this is also legislated by the European EU Commission. But as we know from the follow-up reports, that even though this has been legislated, it doesn't necessarily mean that all these provisions have been consistently implemented across all the member states of the European Union. The USA, where also the interpreter, working with interpreters, introducing interpreters in court has been legislated through a variety of documents on translators, interpreters. As you can see that one of the Court Interpreters Acts talks about interpreters being certified and otherwise qualified in judicial proceedings. Very, very important. The NAJIT, National Association of Judiciary Interpreters, also have their role talking about the interpreter's responsibility. And what is common in all these documents, that the onus, the responsibility for the provision of quality is very much on the interpreter, especially in the earlier days when these documents were developed. So most statutes have a so I'm moving now to the different states. Until now, I was talking about the federal level, but the policy is essentially based on the state statutes or rules, and some are based on precedent from previous trials. So there is a combination of how these provisions originated. Like in Canada, in the United States, these provisions are made not only for a defendant accused, but also for a witness. So the witness enjoys the same provision for working with through an interpreter. And we can see the requirements of an interpreter: quality, follow-up recruitment process by the court, qualifications and certification, official registers of state-based interpreters. There are differences. Different states include different aspects. So, for example, in Massachusetts, there is training for users and judges, a variety of workshops for court personnel and judges. So this is more recent. This goes back to 2009. Or in New York State, there are bench cards for judges, the best practices for judges on working with interpreters. That's 2015. So these are some explanations, but you will note that there are no obligations on the part of the judge or the court. So there is no provision about preparation materials or briefing either. I will skip through Oregon. Well, actually, no, because there are these bench cards or statutes on working with interpreters also looks at the role of the judge in assessing whether the interpretation is correct. I mean, obviously in the form of a protocol rather than the judge's ability to judge the accuracy of interpretation. But there is an emphasis, and that's the last bullet point here, on the assistance assistance in preparing the interpreter, or helping them obtain access to all the relevant documents. Now, when we moved from the international scene to Australia, I felt submerged by a huge number of policy documents upholding the basic principles of access and equity. Australia does ratify UN resolution and other international documents, but there is no legislation on interpreting in court and other settings, legal settings. There is an enormous amount of policies, protocols, guidelines, standards, bench books, reports, submissions, recommendations, and so on and so forth at both Commonwealth and state territories level, and also generated by various organizations. And the principle of access and equity seems to be the foundation, not to disadvantage anyone because of language barrier. And here are some commonly accepted standards. It's the right to a free provision of an interpreter. Nobody challenges it anymore. Follow the proceedings in the defendant's or accused's own language, the expectation of NAATI certified interpreter, and adequate working conditions. NAATI certified where possible, in languages where this is possible. Now, there are certain provisions by OSIT and by ASLIA. There are professional associations, and there are guidelines that also recommend certain ways of working in courtroom settings. Now, there are certain Commonwealth policies and guidelines, again, developed over the years, but you will see that some of them are fairly recent, or rather they have been updated recently. And a lot of them come from states and territories. Again, they are consistent because they are all based on the language service policies that are consistent generally. But different states introduce different types of documents. So, for example, a local court's bench book in New South Wales, again, focuses on the obligation to provide an interpreter, the Northern Territory, there is a greater emphasis on the Non-Discrimination Act, on Health and Community Services Act. So there is a reference to the legislation that does not necessarily address interpreting matters. I would like to highlight something, because, and again, I'm skipping here, but I think what is important to say is that the watershed in the development of these policy documents has been the publication of the recommended national standards. And this is a document that I personally find the most comprehensive nationally and internationally. It's a most comprehensive set of standards for all the participants. And it includes the role of the judge in terms of their own actions, the way they interact with interpreters, and the way they monitor and interact with other participants, or should I say, the way they should. Now, post recommended national standards, we notice that several jurisdictions have included, they have literally either referred to the recommended national standards or they copied entire chunks from them to ensure the best way to work with an interpreter. So there is a lot more about and for the judicial officers, for example, in Queensland, training judicial officers, how judicial officers are encouraged to speak. I have to skip again quite a lot of what I'm saying in order to conclude that this large volume of documents, where they are listed on 7 pages, they reflect the evolution of legislation and policy on the right of the accused in criminal proceedings. And the development consists of the fleshing out of these principles in the form of policies, protocols, and guidelines. And for a long time, they mainly focused on the responsibility of the interpreter. And international courts have been also developing these provisions in response to practices, but in addition, they improved working conditions. So the legislations and policies for domestic courts have certainly evolved in terms of certification, ethical behavior, competence, but they have been slow in recognizing that interpreters need support and that the awareness of judicial officers and lawyers to their role needs to be raised. And so the recommended national standards is a comprehensive set of standards that fills in many of these gaps. And they have already influenced state and territory-based documents. So the question is now about non-adherence to these guidelines. And we know that there is non-adherence, not only from our short-term observations and interviews, but also from the reports that follow these policies and guidelines that repeat over and over again, especially with regard to indigenous languages, that the situation remains very much at the status quo level. So it requires a careful planning and joint effort of all the stakeholders, including courts, to change the attitudes, to raise awareness and incentivize the users to implement all these policies, and primarily those that are so well articulated in the recommended national standards. So I will stop here. Sorry to slightly go over time, Vicky. We decided not to have questions and answers after this presentation, but leave them until Dr. Vicky Wong, our PhD graduate of University of New South Wales, supervised by Sandra Hale and myself. And currently, Vicky is working for NAATI. And we're very happy about this development. So Vicky, I will let you introduce your topic, and please, over to you.
Thanks, Lumila. Good afternoon, everyone. And thanks to Lumila again and Sandra for the opportunity for me to share with all of you some findings of my PhD study. My PhD study looks at the role of preparation using case-related materials in court interpreting. As part of the study, I conducted a survey of court interpreters' preparation practices and attitudes towards preparation. I also conducted an experiment of court interpreting accuracy. Today, my presentation will focus on the experiment, and I'll share with you some interesting findings from the quantitative and the qualitative perspectives. And the title of my presentation today is The Effect of Preparation on Interpreting Accuracy. So I mentioned quantitative, which means I used statistics to analyze numerical data, aiming to make inferences from the sample to the wider court interpreter population. Qualitative means that I looked at non-numerical data, which are the interpreted renditions of the experiment participants, aiming to gain some in-depth insights. So here again is the topic of my presentation today. First of all, I would like to talk about the term of case-related materials. The term is borrowed from Stern 2012, where she discusses the obligatory preparation requirement in international courts of justice. I contextualize the term to refer to the documents or information pertinent to the substance of a legal case, which are readily available to court administration and professional participants such as judges and lawyers. The term is not intended to be exhaustive, and some examples include expert reports, witness statements, and medical reports. Now I'll move on to the experiment. In the experiment, each participant completed 2 interpreting tasks, one with the provision of an expert report in advance and one without. So the 2 treatment conditions are with versus without the provision of an expert report. I will say with report and without report condition from now on. So we have, there are 2 interpreting tasks. They are different, and one represented a murder trial and the other represented a drug trial. The 2 tasks are different but comparable in various aspects, such as the number of turns, word count, overall lexical density, readability, etc. They both featured an examination in chief of an expert witness for the prosecution. In the murder trial interpreting task, the expert witness is a clinical psychologist. In the drug trial interpreting task, the expert witness is a police officer who specialized in drugs. The materials used in both tasks were adapted from authentic materials. The experiment was conducted in a language lab for recording purposes. For each task, the participants listened to an audio and interpret the content from English into Mandarin using the whispering simultaneous mode, as if they were whispering the content of the examination in chief to the defendant. Because of the nature of the interpreting task, the interpreting accuracy that I looked at focused only on the propositional content. In the experiment, the interpreter was not directly involved in the examination in chief between the prosecutor and the expert witness, and the entire exchange was in English. So the interpreter's renditions would not affect any pragmatic forces intended in the lawyer's questions or affect the judges or the jury's assessment of the expert witness. Okay, this slide shows you how I allocated the 2 expert reports to the participants. For each cohort, half of the participants received a report related to the drug trial, and the other half got the report related to the murder trial. So altogether, 26 participants successfully participated in the experiment. 14 of them were interpreting practitioners, and the other 12 were interpreting students. So this slide shows you the counterbalancing adopted in the experiment. So take the practitioner cohort as an example. The participants in the darker colored bars completed the drug trial interpreting task first, and the participants in the lighter color bars completed the murder trial interpreting task first. So here you can see some participants had received a report related to the drug trial interpreting task, and some received a report related to the murder trial interpreting task. Okay, now you can see that there are some stars there. The participants who are under the stars completed their first task under the with report condition. So for example, for those who had received the report related to the drug trial, they completed the drug trial interpreting task first. Those who received the report related to the murder trial completed the murder trial interpreting task first. The rest of the participants, that is those without the stars, completed their first interpreting task under the without report condition. Counterbalancing was adopted to reduce potential bias that can be caused by the effect of the order of treatment conditions or the order of which interpreting task first. Okay, next slide is about the assessment of interpreting accuracy. The entire audio script was broken down into 20 propositional chunks based on the key messages, meanings, and informational elements in each chunk, guided by the questions asked by the prosecutor. There are 20 propositional chunks altogether, and each carries a maximum of 5 marks. So the maximum mark is 100 in total. 2 markers listened to the audio recorded renditions and carried out the assessment. I ran statistical tests to analyze the 2 markers' iterator reliability. I also did some preliminary analysis. In further statistical analysis, which today's presentation is based on, the average scores were used. So here are some highlights of the results. The first one I would like to talk about is the within participant differences, which means the differences shown by the same participant under different treatment conditions, without report versus with report conditions. The result was that there was a significant main effect of the provision of an expert report on the level of interpreting accuracy in the student cohort, in the practitioner cohort, as well as overall. So here is a graph showing you the mean score achieved by the participants. The red bars represented the practitioners and the blue bars represented the students. On the left-hand side is the without report condition, and on the right-hand side is the with report condition. You can see that both students and practitioners achieved a higher level of interpreting accuracy under the report condition. Next, I would like to talk about the between participant differences, which means I'm comparing participants in different treatment groups in an interpreting task. So the first one, the murder trial interpreting task, there was a significant effect detected as well in the student cohort, in the practitioner cohort, as well as the overall. So here you can see that this graph is pretty similar to the previous one. Participants in the report with report group outperformed those who were in the without report group in the murder trial interpreting task. Now I'll talk about the drug trial interpreting task. Again, there was a significant main effect detected. The effect was detected in the student cohort as well as overall, but not in the practitioner cohort. I'll explain why. Now this graph is similar to the previous one, except that statistically significant main effect was not detected in the practitioner cohort. You can see I use pink color bars to differentiate. So the difference was not detected at the required p-value level. What it means is that there's a more than 5% risk of concluding that a difference exists when there is actually no difference. We have to note that this does not indicate an absence of practical significance or an absence of effect. It just indicates that it hasn't reached the required risk level in statistics. Now, I'll turn to the qualitative aspect. The theoretical framework that underpins the analysis is Daniel Gill's effort models of interpreting. Gill's effort models explain the relationship between the cognitive processing capacity and requirements during interpretation, and explain why interpreting failure occurs. In Gill's terms, there are different interpreting efforts required in the act of interpreting, such as listening and analysis effort, memory effort, production effort, and coordination effort. Gill hypothesized that in the act of interpreting, various interpreting efforts are active and competing for the available processing capacity. When the processing capacity requirements exceed the available capacity, saturation occurs. And cognitive saturation leads to interpreting failures. Saturation also occurs when there are cognitive problem triggers, which are types of content that have a high level of processing capacity requirements. So, according to Gill, cognitive problem triggers are types of content that are prone to causing interpreting difficulties. There are different types of cognitive problem triggers, including specialized terminology, enumerations and low redundancy, numbers, fast speeches, strong foreign accents. I used Daniel Gill's framework and some of the cognitive problem triggers to analyze experiment participants' interpret renditions. So this line shows an interesting example taken from the drug trial interpreting task. In the drug case, the defendant was arrested at his premises, and a number of items were seized by the police, including cocaine in pure form, a large quantity of $50 notes, weighing scale, resealable plastic bags, and chemicals commonly used as cutting agents to dilute pure cocaine. The defendant was charged with possession of a prohibited drug taken to be for supply. In the examination in chief, the prosecutor asked the expert witness, "What are cutting agents?" In the expert witness's answer, he explained the purpose of using cutting agents and cited a list of typical cutting agents. The cognitive problem trigger presented here are specialized terminology, such as the term cutting agents and the term sodium bicarbonate. Another cognitive problem trigger is enumerations. The expert witness enumerates 7 typical cutting agents in his answer. Now let's look at how the practitioner participants interpret the term cutting agents. In the with report group, all 7 practitioner participants were able to interpret the term cutting agents into Mandarin as something used to dilute cocaine when the term was first mentioned, which means it was before the expert witness explained the purpose of using cutting agents. And out of the 7 typical cutting agents, 3 participants in this group were able to accurately interpret 6 of them. And in the without report group, 5 out of 7 practitioner participants, when they interpret the term, referred to the action of using sharp objects to cut something before the expert witness explained what cutting agents means. 1 participant only interpreted the word agent, and the other participant did not interpret the term at all and omitted nearly the entire propositional chunk there. And out of the 7 typical cutting agents, 2 participants were able to interpret 5 out of 7. And 1 participant only interpreted chemical substances. Now let's look at the second term, sodium bicarbonate. So in the WIF report group, 4 out of 7 practitioner participants accurately interpret the chemical term. 3 of them rendered the chemical name in full. 1 of them rendered the common name, baking soda. But in the without report group, none of the practitioner participants interpret this term. It was totally omitted. We have looked at some of the quantitative and qualitative findings of the experiment. As you can see, there is strong empirical evidence that supports court interpreters' need for case-related materials to enable preparation. As demonstrated in the study, it helps court interpreters to achieve a higher level of interpreting accuracy and overcome some types of content that are prone to causing interpreting difficulties. Preparation would help court interpreters acquire the substance of or the knowledge about the legal case they interpret for. It would also reduce the processing capacity requirements by the interpreting efforts and lower the risk of cognitive saturation and interpreting failures. While my experiment is the first of its kind in court interpreting studies, the key message is not new. Here are some teachings of the interpreting literature. Preparation is actually a form of knowledge acquisition. The need for preparation to assist in the interpreting process goes beyond interpreters' preferences, is necessary. Comprehension is contingent on the interpreter's pre-existing knowledge. When interpreters undertake preparation, they are actually activating and increasing their familiarity of the source language and target language information. Court interpreting enables effective communications between the language minorities and the courts. And it's important to remember that the contribution made by court interpreting goes beyond assisting the language minorities. It also assists tribunals and courts in carrying out their duties to decide cases. It enables decision makers to better heed, understand, and consider the relevant issues. Today, I have presented empirical evidence to complement the relevant recommendations made in the recommended national standards. It is hoped that court interpreters will no longer be asked to carry out their duties without the provision of any case-related materials. It is also hoped that court interpreters will be able to undertake targeted preparation using the materials provided to carry out their ethical and professional duties and to assist them in achieving interpreting accuracy. All stakeholders need to remember that only when interpreting quality is ensured can court interpreting effectively contribute to the administration of justice. Court interpreters should be supported with working conditions which are conducive to their achieving interpreting accuracy and carrying out their professional duties. That's the end of my presentation, and thanks everyone for listening.
Thank you very much. Thank you, Vicky, for an excellent and very focused presentation. Well done. Stephen, would you like to take the questions? And if anyone in the audience have other questions, please use chat and Stephen will moderate the Q&A.
Fantastic. Thank you, Ludmila. Thank you, Vicky. So the first question from Rima was to Vicky's presentation around when was the report provided? Was it on the day of the trial or prior to the trial? Could you give us a little bit more info?
Yep, in the experiment, the report was provided about a week before the experiment.
Yeah, okay, I think that clarifies very specifically. Thank you, Vicky. Any further questions either for Vicky or for Ludmila's presentation beforehand? How were the reports requested? A follow-up from Rima. Thank you, Rima.
How were the reports were requested? Sorry, Rima, I don't quite understand the question. Did you mean how I prepare the reports for the experiment? If that's the case, actually, I drew on my legal background and drew on my legal experience as well. Oh, sorry. Oh, sorry, I was just distracted by the second question. Anyway, yeah, so the report was prepared by myself based on the authentic materials that I adapted from. Yeah.
Sorry, were they not? So you didn't request them from the from say DPP or those departments?
Oh no, I didn't.
Oh, okay. Yeah. Thank you.
Thank you.
And a follow-up question from Francoise. How long before the experiment? I think you said 1 week, was it, Vicky?
Yeah, the reports were provided about a week before the experiment. Yeah.
Some more information from Shi about how you selected the practitioners. Was there any particular profile that you were interested in, demographics and so on? Could you tell us a little bit more about that?
Sure. When I recruited the experiment participants, they have to be, for the practitioner cohorts, they have to be practicing court interpreters. But I didn't limit how many years of experience I was looking for. So all of them are practicing court interpreters.
Okay, excellent, thank you. Another question from Sean. In a real life situation, what kind of document would you regard as being a useful report?
I guess it depends on the case, and it's difficult to tell. But as I said, case-related materials include some expert reports, witness statements, and which goes into the substance of legal case, as opposed to peripheral information like a charge sheet and things like that. Yeah.
Excellent, thank you. Another question from Long. Could you elaborate further on the statistical insignificance in the practitioner group? And would it be fair to say that that suggests that highly experienced interpreters won't need as much preparation?
No, actually, I don't interpret it that way. And actually, in the practitioner cohort, in the drug interpreting task, that no statistically significant difference was detected, could be due to the number, the sample size. Yeah, so if we could get more participants, we may be able to reach the statistical significance level required. And actually, it highlights the methodological challenges in interpreting studies, because it's difficult to recruit enough participants.
Of course, excellent. Another one from Uldis. I'll just read out. One of our participants, Francoise Matthews, in a report of a long criminal trial, was asked by judicial authorities before the trial what she needed. She provided a long wish list, including preparation materials, and had all of her wishes accepted. Does this indicate that interpreters need to be more active in requesting such? And is it the case that many interpreters are perhaps not asking?
So is it the question for me, Stephen?
Yep.
Okay, cool. Yeah, definitely. Actually, it's not the focus of my presentation today, but I did do a survey of court interpreters' preparation practices. And actually what I found is some interpreters did receive some documents, which was very useful to their interpreting assignments. Some did not. So I would just suggest you need to take the initiative for court interpreters to make a request first.
Excellent, thank you, Vicky. And just a note from Francois saying that it was for a murder trial in Western Australia. Question from Alexandria. She's saying that she knows barristers fear case preparation materials will make interpreters biased and prefer them to interpret in the dark, even if it means that they might have risk of inaccuracies. How can this fear be myth-busted? How can we weigh up the two different kinds of inaccuracy, i.e. from bias versus lack of background briefing?
I would think that it seems that some judicial officers or lawyers, as Lumila has mentioned at the beginning, still has a misunderstanding about the interpreting process. And actually, if we make it clear to them that interpreters do need these informations to do their job, it may change their attitudes.
Excellent, thank you. And a follow-up from Abigail saying that interpreters are asking, but requests are not always welcome.
Yes, I've now actually in my survey, some interpreters did report that they have received some unwelcome responses. And one interpreter even said that he was reprimanded by a judge after making a request. But let's hope that after the launch of the recommended national standards, the situation will change and will improve.
Excellent, thank you, Vicky. Any further questions either for Vicky or for Ludmila? Oh, just as I was speaking, another one just came in. Do you think some of the results of your study will be applied to future practice and training?
Thanks, Cookie, for the question. Actually, it's a very good question. I don't know how to answer on the spot, but it's very inspiring. I need to really think about that, and thanks for that.
And a comment from Sandra saying it's common practice in international interpreting for interpreters to receive all of the materials that the participants receive. Interpreters need this to interpret accurately. They will not be biased by the information because they are, of course, impartial. Another comment from Rima: when interpreter requests reports or any other documents, Multicultural New South Wales then request them on their behalf. This is up to the officers whether they'll release anything or not to Multicultural New South Wales and then on to the interpreter. She's noting that we need to do much more education in this space.
Yeah, I agree.
Yeah. And another point from Long, agreeing with something earlier. Yeah.
Cool.
Thank you all so much for the questions so far. We've got just a couple more minutes. Another follow-up around myth busting will be by training barristers and judges also. This goes back to our earlier point, that the trial judge may do request can be made. The key here is the Crown and identifying early who the interpreter will be. And of course, this speaks back to a lot of the points you are making, Vicky. Any response?
Well, I agree, absolutely agree. Training barristers and judges is necessary. Yeah.
Can I just jump in
Please.
and ask in the response to Justice Kunz's question? So what do you think would be the most convincing, the most persuasive argument to change the attitudes of the judges and the parties regarding the provision of information and briefing?
Are you asking me that question?
I am, yeah.
I think the provision, for example, of the study that Vicky has been talking about, judges will be impressed by empirical data to show that you actually get a better result. I mean, I would say it confirms what one would like to think would be the common sense conclusion. But the point I'd just like to emphasize in crime, which is not my principle, not my area, but I know enough about how it works to say a lot of judges who do the trial will not do the pre-trial directions. So you really depend upon the Crown to be the place who receives the request, and you do need to know who the interpreter is going to be so that they can be done in advance. One of the problems we have is that I think we still see interpreters as a last-minute task in terms of the organisation of a trial.
Can I just take up from what Francois said? It's Chris Karakis here from the Supreme Court of South Australia. We've established a user group that meets several times a year, interpreters, judicial officers, registry staff, and we're attempting to deal with this problem. I don't think there is a reluctance to do it. I think everyone appreciates the benefits of it. The problems with too much information or bias, I think, can easily be managed, and most judges probably think that. The real question is one of logistics, how you provide the information in a timely way. In our courts, the prosecution provide a summary of the case, which the court gets early on, and we're trying to put arrangements in place whereby the registry staff who book, mostly using emails, interpreters provide those summaries to the interpreters so that they have some familiarity with the case before they come into it. But just to summarise again, I think it's largely a matter of logistics and courts organising it, because, as Francois said, a judge hearing the trial isn't involved in the preparation and probably gets it on the morning or perhaps a day or so before.
So I could say at our recent meeting of our committee, Chris, we heard about your users group in South Australia, and I think it was enthusiastically adopted as a very good idea around the different states. So people who are participating in this, who are connected into that sort of place, should encourage their local courts to start such a users group.
Well, thank you. And by the way, just I would like to welcome the Chief Justice Kourakis, who initially was not going to be able to join us. So I think we have now come to the time of our short break of about 12 minutes. So let's reconvene at 5 to 3 Sydney time. So we're taking about 10 minutes break, and you will see on the screen the list of participants of the panel. The panel will take place a little bit later in the afternoon, and we will start part 2 of the symposium with 2 presentations by Sandra Hale and by Erica Gonzalez. And then we will move on to the panel discussion. So please don't log out, maybe just close your video cameras, and we'll see you at 5 minutes to the hour. And thank you for your participation and attention.
And if anyone wants to add any further questions or comments, I am making note of them as they're coming through, and we can perhaps pick up on them later. So please feel free.
Yeah. Thanks, Stephen. Okay. I can see Stephen. Hi. And hopefully other participants, other audience members are coming back too, so that we can move on to the next half of our symposium. I can see that there is a conversation in chat, and I wonder whether we can pick it up later on, maybe after Sandra's paper, because it is likely to be relevant. So Sandra, if you are ready, I'd like to invite you to present your paper.
Thank you, Ludmila. I'll just share my screen. Okay, so the title of my presentation today is How Far Have We Come in the Past Decade? And it's a bit of a stock take exercise to see what we've achieved and what we haven't achieved yet. So by way of introduction, I think this was said before, but I'll just frame it in these principles that quality interpreting is crucial to ensure equitable outcomes. And I'm sure everybody in this audience agrees that interpreters interpret for all participants, not just for the non-English speaker. And this is something that I think many court participants have not realized yet. They tend to think that the interpreter is just there to help out the person who doesn't speak English. Well, the interpreter is there for everybody. And so if the interpreter is not a good interpreter or is not able to interpret accurately because of all these other extra issues that we've been discussing, then all of the participants will suffer, not just the non-English speaker. And that quality of interpreting depends on a number of factors. obviously the interpreter's competence is number one. That is the first thing that needs to be ensured, that the interpreter is adequately trained, qualified, certified, etc., etc. So that's number one. Without that, nothing else can work. But the second one, as we've been discussing, is the working conditions. So an interpreter, no matter how good that interpreter is, will not be able to perform adequately if they are not provided with adequate working conditions. And that is true for any professional. So it shouldn't be something that is surprising, but unfortunately it is. And the other point relates to the expectations and the behavior of the end users. So they need to understand that the way that they act will also impinge on the ability of the interpreter to interpret accurately, and the expectations. You can't expect an interpreter to interpret accurately when the speaker is making no sense, or when they are going too fast, or when they don't give them time to have a break, or preparation materials, etc., etc. So all of these things go together, and everybody must, as I always say, assume some of the responsibility for the effectiveness of the communication. So what have been the recent positive developments? And I always like to stress the positive, because that's the only thing that gives us hope to continue fighting for these things. If we see no positives, then we will give up. We have a lot of positives. So I'll just go back, as I said, only a decade. So in 2010, there was a conference in Fremantle organized by the AIJA on interpreters working with legal professionals. I can't remember the exact name. And at that conference, it was evident that there was no consistency across the country, not even within states, about the understanding of interpreter roles, about how interpreters work, what they need, what they don't need, what the protocol should be, and so on and so forth. And so I was lucky to be funded by the AIJA to conduct a national survey of interpreters, judicial officers, and tribunal members, which then produced a number of recommendations. So that was in 2010. In 2011, I received the first ARC-funded research money to research court interpreting. So this is where funded research started into court interpreting, which is a huge milestone, because before that, after many attempts by many of us to receive research funding, there was no research funding for interpreting research. So this started the ball rolling for other research projects. In 2012, NAATI conducted its first complete review, and we can see the NAATI INT report, improvements to NAATI testing report, which was also a huge landmark, because there were also 17 recommendations from the review, and all of those recommendations were accepted by NAATI to various degrees, and this included a specialist certification for legal interpreting, as well as pre-certification examination training, not necessarily university training, but training for all interpreters to have a basic type of training. Before that, there was no requirement for interpreters to be trained at all. And post-certification examination professional development. So the profession is moving towards improving itself. So back to the first comment that I made, number one is the competence of the interpreter, and there are many initiatives that have been put into place in order to ensure that the competence of the interpreter is achieved, at least in the major languages, but there are initiatives for the less, of the rarer or new and emerging languages as well. So in 2011, the AIJA report was published, and one of the recommendations that I had there was the development of a national protocol for working with interpreters in courts and tribunals. And at that stage, I was told, no, that is pie in the sky, impossible to happen, because we have different jurisdictions across the different states, and it would be impossible. So some courts, including the Northern Territory and so on, developed their own protocols based on the recommendations, which was great. But I thought, okay, well, that's as far as we can get. But in 2015, I received a letter from the first chair of the JCCD, which was the new body, and the first chair was Chief Justice Wayne Martin, to invite me to write such a protocol with a retired judge. So that was a great letter that I received, which was fulfilling one of those major recommendations. Now, that group, or it was just two of us at first, but then we extended it to create a committee, which then it became a lot bigger than just a protocol. And we got together with representatives from the law, from interpreting, from Migration Council, and so on and so forth. And we produced the recommended national standards, which is, as Ludmila said, something to be very proud of, because it is, I agree, by far the best document in the world regarding interpreting in courts and tribunals. Many people around the world have read it already, and it's been translated into Spanish, and it is comprehensive, and of course there are changes and amendments and improvements to be made, but it is a document that we should really be proud of. And it was launched in October 2017, and this is what we're talking about mostly now, and we're currently talking about our current ARC linkage project to study, obviously, as Ludmila explained, the communication practices of judicial officers, but also the implementation of the recommended national standards. So we've got the first step, which is the document itself, but now we have to move on to the implementation, because a document with no implementation is not very useful. So unfortunately, there has been little progress on some aspects in the past decade. So again, working conditions. As we've just heard, very little in the way of pre-assignment information, materials, or even oral briefing for interpreters to be able to prepare adequately, to do the job adequately. Working conditions in the court have been less than adequate, in particular with regards to interpreters sitting next to the accused, whispering in the ear. And this is something that has happened forever, and we've been talking about this for a long time, about the uncomfortable nature of it. But now with COVID, it was a real life-threatening situation, and very little was done about it. And in fact, we observed in some of the courts that we went to observe that some of the interpreters did object to it, and they were told, well, other interpreters don't mind, so, you know, we can't do anything about it. So treatment by other court participants, and this is something that's important, that, as Ludmila already mentioned, the judicial officers are the ones that treat the interpreters the best, and interpreters have said that, but the court is made up of many other participants, and the treatment by others has not been ideal. And this is a quote from an interpreter from the first report that I mentioned, the AIJA report in 2011, who said, "How can we be respected as a professional when not treated as such? How can we be expected to do our best when our working conditions are not conducive?" So once again, going back to that point of expectations, if interpreters are expected to act professionally and to interpret accurately, they have to be treated as professionals, and they have to be given the adequate conditions that they need in order to be adequate. The next point where we have probably gone backwards is remuneration. And this is, I know that it's a sticky point and most people don't want to hear it, but I need to stress it, because if this doesn't change, we will be left with no professional interpreters, no certified interpreters, no competent interpreters working in the courts. So they'll just refuse to work for the amount that is quite ridiculous, because they can get paid a lot more if they go and do factory work, cleaning, gardening, whatever other non-professional work will pay them more than working as interpreters in court, as significant as that work is. On the one hand, we've seen, as I already mentioned, the improvements to the interpreters side of things, to improving the quality of interpreters, to improving the training of interpreters, the certification of interpreters, the need for professional development, which has increased the costs to interpreters. On the other hand, the remuneration, so the award for doing all this extra work, has decreased or continues to decrease, and that's something that cannot be ignored. So a few other quotes from the 2011 AIJ report from another interpreter. There is a general dissatisfaction among interpreters, and it seems that all the complaints fall on deaf ears. Not surprising that not many are ready to accept the legal tribunal interpreting jobs nowadays. Another one from a judicial officer from that same survey who said no preparation required by interpreters. They are simply translating literally what is said in court verbally. So this shows the misunderstanding of some judicial officers about what interpreters in fact need to do a proper job. And a lot of this has been overcome by the training that we've been doing for many years. For 20 years, in fact, Ludmilla and I have been training the judiciary. And we've seen, and I have observed those judicial officers who have done the training. It is not difficult to learn how to work with interpreters. You know, awareness raising is the first thing. And as we've just seen from empirical research, that preparation is required in order for interpreters to interpret accurately. Interpreters don't translate literally what is said verbally in court. So from this AIJA report, 2 out of the 16 recommendations were implemented. Number 5, which was the NAATI specialist certification, which is being rolled out now, and number 16, which is the national protocol, which in fact became something more than national protocol, which is the recommended national standards. Now, the other research project that I mentioned, the other ARC research project that I mentioned, also, had observations in New South Wales, Victoria and Queensland during 2011 to 2012. And again, these are some of the results that we found. Recruitment practices were ad hoc. The job for interpreters was insecure, inconsistent. There were inefficiencies, as we have seen now. There were multiple interpreters booked for one language, where 2 interpreters could have worked together as a team rather than having multiple interpreters working in opposition to each other and checking up on each other in what has been referred to as adversarial interpreting, which goes against quality rather than being conducive to quality. Interpreters booked to sit around waiting, doing nothing, wasting time, wasting funds, wasting resources, where other courts may have been needing them but not being able to access them because they were sitting around doing nothing in some other court. Interpreters' qualifications not seen as important. So there were interpreters with very good qualifications, postgraduate qualifications, NAATI in that at that time, NAATI accreditation, and there were some interpreters who were barely bilingual. Working conditions, and we also did observations and we had our notes, and this is from one of the researchers' notes in the team, observing, and this researcher in our team was not an interpreting expert, was a sociologist, and this was something that caught his eye, saying the interpreter was in the dock, the 2 interpreters kept going without a break. In the dock, the 2 interpreters kept going without a break, so they were leaning towards the person for whom they were interpreting in what seemed to me a rather uncomfortable position, likely to produce a sore neck. The convenience of the jury was certainly mentioned, but never the convenience of the interpreter. The witness was told to sit down, but nothing was said to the interpreter. The jury were thanked, but not the interpreter. So again, I don't think this is done on purpose, but it requires an awareness raising of the fact that the interpreter, 1, is a person, 2, is a professional, 3 is a professional who needs certain requirements to perform, who gets fatigued, and who needs to be acknowledged. And acknowledged in the sense of being thanked and also being asked for what they need, and in particular given breaks, and in long trials, as I think Ludmila mentioned, they need to work as a team of 2 rather than by themselves. It is, again, fatigue is another area that has been researched that shows the level of accuracy goes down when the level of fatigue goes up. In 2011 and 12, for the survey of 194 interpreters about the perceived status as part of the ARC project, came up with a number of interesting comments from interpreters themselves about how they perceive their own status. So the first one says, no one really cares much about interpreters. They often believe we're a burden or waste of time by most participants other than the defendant. Court officers need to be trained to respect the functions of court interpreters and accept that we are part of the legal system rather than a burden on their work. The last they think of is the interpreter's comfort. Once in a big trial, I was looking in my iPhone for a word and the judge asked me if I could stop using the phone. Not that often are interpreters shown respect, acknowledgement, or appreciation for the service they offer. Now, I want you to think about these comments. No one cares about us. They need to know what we need. We're a burden. They don't think about our comfort, etc., etc. Who would want to work under such conditions? Just think about your own jobs. Those of you who are not interpreters, would you feel comfortable working under those conditions day after day? I don't think it's a very inspiring situation to be in. Now, almost 10 years ago, what have we found? So these are very, very preliminary observations. So we can't say that these are the final results. And I hope that in the coming 2 years, we will be able to observe more cases that are more positive. So what we found in our short few months of observations in New South Wales in 2 courts is that most court participants have not heard of the recommended national standards, as Ludmila has already said. We also found, to our dismay, that some of the interpreters had not heard, and I made the link that most of these interpreters were not AUSIT members. So not all interpreters are members of the National Professional Association, which is alarming. And because they're not members of the National Association and they work in isolation, they don't get to hear about the new the new initiatives and the new policies, and so they're really isolated. So this is something that is a problem, maybe something for the language service providers to take up. We found that the good interpreters, the ones who were adequately trained, experienced, assertive, who knew everything about the national standards, would ask for what they needed, and often their requests were rejected. So yes, Aldis mentioned in his comment before that when interpreters ask, they usually are given what they ask for, and that is true for some interpreters, but not for all. And in what we have observed, that was not the case. The work health and safety issues were completely ignored, mostly because I suppose interpreters are not seen as being employees of the court. As Ludmila already mentioned, there was no social distancing during the COVID time. There was no equipment given to interpreters. Even the loop for hearing more adequately, interpreters were not given that as a matter of course, and some, when they were asked, were rejected that as well. There was no briefing, and I'm talking about oral briefing. So most of the time, interpreters were not briefed at all. Sometimes they were by some of the lawyers, but that was the minority. Most of the time they were not, and when they asked, they were told that they didn't need it. Few breaks, and the breaks were simply mostly for the rest of the court participants. No one asking the interpreters if they needed a break during the long interpretation, although some judicial officers did say to the interpreters, if you need a break, please ask, but the interpreters are often too shy to ask for breaks, or they don't want to be more of a burden, and so they don't ask for breaks, or they don't, and this the research backs this up, that they don't realize they are fatigued until after the performance has already deteriorated. So it shouldn't be a question of, do you need a break? It should be an automatic break given after a certain time. And there was no team interpreting, and it was very noticeable with long trials, very difficult trials, that the interpreter would have really benefited from having a team member working with that interpreter, which is the standard practice in international settings. So this is an example from one of the interpreters. And I asked for permission to share it. And I've got the question, after I read this, do you think that this is what an officer of the court should be treated like? We have in the recommended national standards that the interpreter is an officer of the court. So the court officer says to the interpreter, you cannot bring the phone into the dock. The interpreter says, but what should I do if I need to look up any terminology? Court officer, well, others use pocket dictionaries. Interpreter, but I won't be needing to look up words like chair or table, which is what you find in pocket dictionaries. I would need to look up technical, specialized words. And in the 21st century, interpreters use electronic dictionaries and the internet. Court officer, well, these are our rules. You can discuss them with the judge if you want. We don't allow you to have the phone in the dock, because if we see you using it, we don't know what you're doing. You might be sending messages to someone. And the interpreter says, as a commentary after she sent us this, I'm not sure if the above remark made me feel more like a little schoolgirl or like a criminal, but certainly not like a professional. And I would say certainly not like a court, like an officer of the court. And I've highlighted the deictic references there, the pronouns, because it is very clearly us, the court, and you, the interpreter, the external, the outsider, the stranger who is this burden, this nuisance that's coming in. Our rules, we don't know what you're doing. The suspicion that you might be, I don't know, maybe you're a spy, or so. In cases like this, okay, there might be a security issue, then the interpreter should be provided with a working station like the court officer is, like the judge's associate, like the sheriff, like any participant in the court, with a court computer that links to the internet. And then there is no issue of you and us, and there's no issue of security. And I think that's a very easy solution if security issues are a concern. So major achievements have been evident in the past decade. One of the main things that I always highlight is the number of judicial officers that have received the training on working with interpreters and that have become aware of the issues and have become champions and allies. And we've got quite a few of these judicial officers here present today. And we could not have reached this recommended national standards document finalization if it weren't for the support of these champions. Back when I started working on this, I was one of the few very small isolated voices out there. Now we have people who can help us achieve these changes. So that's a huge achievement. And I share this with people internationally, and they have they tell us that they wish that they had judicial officers in their countries who were as sensitive and as open-minded as the Australian ones. So even though we are complaining about the current situation, we mustn't forget that we have achieved amazing results and that we have amazing people working together in order to achieve these improvements. So the launch of the recommended national standards in 2017 led to higher levels of awareness. And we know that those who are aware of the recommended national standards and have read them have implemented them as much as possible. And I was lucky enough to observe one of those great judges who was able to do everything according to the recommended national standards, and the interpreters were so so grateful to this judge because of the way that they were treated. Interpreters really appreciate being treated as professionals. It doesn't take too long or too much effort to do that. So what next? So I think we have to stress that doing nothing will lead to the erosion of quality and to a large exodus of good interpreters. There's no doubt in my mind that this will happen if we do nothing. But luckily, we will do something, so this won't happen. Obviously, there are unknown consequences at the moment regarding the poor quality of interpreting, either because of poor quality of the incompetence of interpreters who are being hired, regardless of the qualifications, or because of the poor conditions under which the interpreters are working. So we need a strategic plan to ensure the sustainability of the profession. We desperately need the court registries, the Department of Public Prosecutions to become involved so that they understand the issues and they help us achieve improvements. And I know this is beyond our scope here, but we can't forget that interpreter remuneration needs to improve in addition to working conditions so that the profession can continue to improve and can be sustainable. So I'll finish here and at the end I'll come up with some recommendations after hearing everybody else's comments. So I'll stop sharing.
Sandra, thank you very much for reminding us of the achievements and what else needs to be done and the risks of the profession, to the profession. We are slightly behind time, so perhaps if are there any questions? Does anybody have anything to raise with Sandra? Alternatively, I can't see anything in chat. Alternatively, perhaps we can go to Erica's presentation and then use the Q&A after Erica's paper to address both Sandra and Erica, if it's okay. Yeah, Sandra, you okay with it?
Yeah, sure. Yep.
Great. Okay. Well, I now would like to introduce, by the way, I noticed that I did not introduce Sandra. I think let's assume this is not necessary. Erica, I know that many of those present here know you well. Erica represents OSIT as a national president. She is also our partner, representative of our partner organization, OSIT, and she's an academic at RMIT in Victoria. So Erica's paper is based on the OSIT survey, the interpreters' voices in response to the implementation of the recommended national standards. So over to you, Erica.
Thank you very much, Ludmila, for introducing me, and thank you very much for the opportunity to participate in this grant with researchers at UNSW. It's a great pleasure for us to be able to contribute meaningfully to this project. So my presentation will focus on the survey we conducted. I'll be presenting the results of such survey, but also I consider that it would be important to present some conclusions, general conclusions, and recommendations.
Erica, we can't see your slide yet, yeah? You may not be aware of it. We see your desktop.
Okay, because you're sharing the screen. Let's have a look now.
That's good.
Okay, I'll go. Yeah, can you see it now?
Yes, great. Thank you.
So basically, we conducted a survey at national level. And as I said, this is product of a collaboration between OSIT, which is the National Professional Association, and UNSW researchers in translation and interpreting. And this is also a side project to the ARC linkage grant project. So the survey was administered nationally between the 18th of October and the 18th of November of this year, and we compiled 452 responses. As you can see in that graph there, the vast majority of the respondents were from New South Wales and Victoria, and respondents from other states, as you can see, the percentages are much lower. The majority of the respondents covered languages in tiers A and B. As you can see, Mandarin, Vietnamese, Arabic, Farsi or Persian, and Spanish were the 5 most popular languages among the respondents, followed by Cantonese, Korean, Dari, which is in tier B, Russian, and Italian. We had also many respondents of new and emerging languages, but we only had 1, 2, up to even 5 respondents of these new and emerging languages, which also shows that these interpreters have less access to news in the profession, to events, and have less chances to maybe access information that is relevant to their profession. In terms of the credentials of the participants, the positive was that more than 50% of those who completed the survey were certified interpreters, followed by certified provisional interpreters, recognized, and some were in the all accreditation system. However, I would like to mention that in some of the responses, it was highlighted by several interpreters that they are concerned that in some courts, still unrecognized or non-credential interpreters are employed to work in courts and tribunals. And these are not always interpreters of new and emerging languages. And we've got instances or anecdotal evidence that in some instances, interpreters in tiers A and B with no credentials whatsoever are still engaged in some cases to work in courts, which is quite alarming. In regard to the education level of those who participated in the survey, the majority hold a master's degree, followed by a bachelor and advanced diploma nearly at the same level, diploma and graduate certificates, graduate diplomas, and skill sets. It is important to mention here that usually people who are well-trained, who are aware of the requirements of the profession, who belong to a professional association, are usually those who participate in this kind of research and surveys. Therefore, we need to be cautious at the time of interpreting these results. And this is also something which has been mentioned or highlighted in previous research conducted by Professor Sandra Hale. I saw that also in my PhD some 7 years ago as well. So this is obviously a pattern that those who are better trained, who hold the highest certification levels are usually the ones participating in this type of studies. One of the things that really caught my attention is that basically half of the respondents work less than once a month in the courts. So as you can see, the work is spread quite thinly. So we've got many interpreters, but many of those do not work very regularly, which I think it's a bit concerning, because I believe, and I think Magdalena Rowan in the chat we were having before mentioned that maybe it would be a good idea to have a register, national register in terms or a list at least of those who are better educated, who hold the highest possible certification levels. And also this will be easier to manage once we introduce the specialist legal interpreter certification, because obviously we might have some really good interpreters who are not getting the jobs, and then we have other interpreters in their same languages, but at a lower certification level, working more regularly than those who are better prepared. So that's obviously a bit concerning. In regard to the awareness of the national standards, the data here show results that are pretty similar to what the research team at UNSW have identified in their observations. So 35% of the respondents were not aware of the national standards. And remember that our respondents were mostly well-educated and also hold certified interpreter credentials. So from those who said that they are aware of the national standards, 52% said that they do apply the national standards, but then there was a section with free comments. And when I started reading and analyzing the free comments, I could see that many interpreters confuse the national standards with the OSIT Code of Ethics. And also when they explain how they apply these national standards, two of the main themes that were highlighted were the request for briefings and also breaks, which is very positive to see that some people, and I was very happy to hear that some interpreters even take the national standards, the hard copy with them to court. So obviously there are some people who are aware of the standards and make sure that the recommendations are implemented. We also asked our participants if there have been any improvements after the introduction of the national standards. And 65.27% mentioned that there have not been any improvements, which is also quite alarming. And then we also asked about the frequency of the application of the standards. 10% said that they are never applied. 76% said that sometimes, and around 12% said that they are always applied. I've also copied here the quotation of one of the interpreters, because I think this citation summarizes quite well the sentiment expressed by many who took the time to write in the comment section. And this interpreter says, I continue to find the court experience completely dependent on the individual presiding officer. There does not seem to be general awareness within the criminal system of the standards, and there are no noticeable changes or improvements to the processes in place to work with interpreters. The only change I have seen is within the civil system, where, after the introduction of the 2020 practice note relating to the standards, I've been engaged by a Spanish-speaking lawyer to site translate a respondent's statement into Spanish before she signed it in English. Before the existence of the note requiring professional interpreting or translation of any documents taken in load by the solicitor and submitted in English to court, I believe my services would not have been engaged. So that's really good to see that some lawyers, some people working in courts obviously have noticed that there are some standards and that it's important to apply them. Briefing. I think this has been mentioned throughout the day today, in the morning, in the session we had with other partners to this research project. It's still a big issue. Nearly half of the respondents, 43.44%, so that's nearly 220 something interpreters, said that they never get briefings. 48%, the other nearly half, say that they get briefings sometimes, and 8% said that the briefing is provided always. Those who said that they do request briefings, more than 50% mentioned that they do have problems when trying to access information to better prepare for assignments. So trying to access information is problematic. And this is something that, as I said, has been highlighted on various occasions, and it's something that we will need to tackle in the near future. In regards to the communication with interpreters, we had a series of questions in regard to how judicial officers and tribunal members communicate with interpreters. So approximately half of the interpreters stated that sometimes, just sometimes, they are greeted, thanked, asked if they need water, breaks, comfortable sitting, etc. They are introduced to other participants. Sometimes also they explain the role of the interpreter to other participants. And on occasions, always, the proceedings are stopped to allow for clarifications, make sure interpreters are keeping up, and request explanations on cultural issues. So when interpreters were asked if they actually themselves interrupt the proceedings, 60% admitting doing so when necessary in order to seek clarifications and repetitions, seek pauses to render the interpretation, explain the interpreter's role, and request speakers to slow down. I think this is really good because more than half of the interpreters are able to do that. But again, let's remember that the respondents, more than 50%, are well-educated interpreters who have completed education at master, advanced diploma level, and therefore they have practiced this in their training. And as you can see, that makes it a massive difference at the time of having assertiveness and the ability to ask for what they need when they are working. So usually, respondents admitted that their interruptions are well received. 21% mentioned that their interruptions are received in a positive manner. Sometimes mostly positive, 33%, neutral, 36%. Negativity is also something that a few of them mention, and saying that the interruptions are always received in a negative manner. And some of them said that always, but as you can see, that's a minority consisting of only 1% of those surveyed. Interpreters also stated that they feel actually comfortable seeking clarification. And as I said, I think this is because of the background and a professional profile of the respondents, as we said, well-educated and working at the highest certified level. However, one thing that caught my attention was that interpreters of certain backgrounds, Koreans, for example, followed by Chinese, and I'm talking about 1/3 of the respondents, found this more challenging than others. And this is a personal hypothesis, and obviously we would have to conduct further research to clarify this. But this could be because the Korean, Chinese societies belong to high context communication cultures as opposed to low context communication cultures such as Anglo-Saxon societies or in Scandinavian societies, where we've got a more horizontal hierarchy in the society. So my feeling is that these interpreters, because they come possibly from cultures where the society is organized in a more hierarchical manner, and because in court they believe that they are not at the same level as those in the top of the hierarchy, it could mean losing face, and they feel really uncomfortable doing so because they come from societies or backgrounds where in these very hierarchical societies, individuals have a very specific way on how they communicate with people in different layers of that hierarchy. As I said, this is just a personal observation, but it does show that some interpreters obviously do not feel comfortable at all requesting clarifications or interrupting the proceedings to be able to interpret more accurately. So more than 45% of the respondents stated that when communication problems arise, judicial officers or tribunals members attribute these errors to the interpreters or these problems to the interpreters, and many of them mention feeling like scapegoats on many occasions. Also, they said that sometimes the errors are attributed to non-English speakers and to a much lesser extent to the lawyers. The vast majority of the interpreters mentioned that they are thankful for the job they do. And I think here there has been an improvement since the last survey was conducted in 2011. Very few interpreters stated that they've been criticized. There were, though, some exceptions, and I'm copying one here because it kind of summarizes the sentiment of others. I've had multiple cases during which at lunch barristers and solicitors have come to praise me for my work. Criticism comes usually from tribunal members, particularly in regards to chuchotage, delays in relay, multi-party interpreting, and unrealistic expectations around site translation. I am mentioning this citation or this quotation because the issue with chuchotage seems to be problematic in many instances. Another interpreter, I remember, that mentioned that the tribunal member said to her, please stop whispering, it's really annoying, when it's part of the job we do. Obviously, this has to do with training. This has to do with the knowledge about the role of the interpreter. But obviously, if those we work with do not understand what our basic needs are, it's going to be difficult to perform professionally. Obviously, as Sandra and Ludmila mentioned before, we believe that with the introduction of technology in courts, some of these issues possibly could be resolved. Approximately 64% of the respondents said that the judicial officers and tribunal members request lawyers to slow down or to rephrase, repeat a question for the benefit of the interpreter, as opposed to 28% who say that this never happens. So obviously there's been some sort of improvement regarding statistics that were shown before. And also many of the interpreters, mentioned that lawyers are also requested to use plain English when they are making their utterances, and also they are requested to avoid long and complex questions. And more than 50% of the respondents also mentioned that judicial officers and tribunal members sometimes address interpreting issues with lawyers. So obviously this was a very brief presentation on quite a lengthy survey we conducted. It contained about 40 questions. So I believe that there might be a few of those respondents among our audience today. So I would really like to thank you for the time you took to complete this survey, because obviously it sheds light on what's happening today in 2020 in our courts and tribunals. So in a nutshell, there have been improvements since the introduction of the standards in 2018, Note 28. So it's important to acknowledge this. I always like to obviously finish with a positive note. The application depends on many occasions on individual judicial officers and tribunal members. So obviously it depends on how familiarized they are with the work interpreters do. If they've been involved with the judicial council, obviously we can see that their work is usually more cooperative in regards to interpreters. The other issue that us as interpreters need to take on board is that many of us are not aware of the existence of the national standards, and the highest qualified and trained interpreters are not always given preference at the time of being engaged in the courts. And as I said, there were allegations of the use of uncertified interpreters in some instances, and not just for languages of new and emerging communities. One of the issues that I have stressed on various occasions is the lack of access to briefing and preparation materials. It is still an issue, and I think this is something that we need to address in the near future. In general, it looks like the judicial officers and tribunal members do appreciate the work interpreters do. And it's also true that there are times when interpreters get blamed for communication breakdowns. Lawyers in general do not seem to apply or be aware of the national standards at the same degree or level that judicial officers and tribunal members are. And there's even more diversity in the way they work with interpreters. And as Sandra mentioned as well in the other presentation, pay rates and working conditions still are an issue. If our best, most senior interpreters do not feel incentivized to go and work in courts, obviously the work is gonna go to less qualified interpreters, which obviously jeopardizes our judicial system as well and the fairness upon which it's been built. As an educator, I see this as really problematic, because the profession is not sustainable. As we said, there are some other non-specialized professions who earn a lot more than an interpreter. And when you've got the students who have gone all the way to get degrees at a master level and have accumulated thousands of dollars in HECS debts, obviously they are not going to continue in the profession if the conditions are so poor. I've got several recommendations that some of them are longer term solutions. Some others, I believe, are easier to implement in a short period. So one of the recommendations is that jobs are allocated to those with the highest qualifications and certification level, that more control is somehow exerted by courts and tribunals in regard to the engagement of interpreters by language service providers who do not always stick to the above mentioned requirement, that the provision of briefing becomes a norm, that booking officers working for language service providers are made aware of the national standards and cooperate with interpreters in regard to requests for briefings. And I know that Rima before said that she obviously, at Multicultural New South Wales, they work with interpreters to ask for the briefings. One of the comments was that, and it was a different language service provider, obviously, but this interpreter said that she called the booking officer, and the booking officer, when she requested the briefing, told her, oh, I just don't want to bother the client, just get on with it. And I'm sure that you can look the information in Wikipedia or whatever. So basically, she was dismissed in quite an unprofessional manner, and the interpreter actually withdrew from the assignment. This is an interpreter also trained at the highest level, certified level, and rejected the job because she believed that without the proper preparation, she was unable to successfully work in that particular trial. It would be also important that language service providers and OSIT keep working on the awareness campaigns regarding the implementation of the national standards by organizing more PD, seminars, networking sessions. That the Judicial Council on Cultural Diversity keeps working on awareness campaigns regarding the implementation of the standards, especially among the newest or more junior judicial officers and tribunal members. That lawyers complete compulsory CPD. I don't know how feasible this is, but in regard to the national standards, including practical role-play scenarios. In our case, interpreters, we have to recertify every 3 years, and we've got some compulsory categories in our certification logbooks. I am wondering if someone working in Australia as a lawyer in a multicultural country where sometime in your professional life, you would probably have to work with an interpreter, or at least with clients whose language is not, first language is not English. I think it would be important to include this as something compulsory. So I think also education is the key to success. So I believe that all interpreting students and newly certified interpreters are made aware of the national standards. And in this regard, educational institutions would have to work hard to promote this. Also, that law schools include a module on working with interpreters in the curriculum based on the national standards. And not last but not least, as I said before, that interpreter remuneration and working conditions are improved in order to retain the most professional and senior practitioners. So that's in a very quick perspective what we gather from our survey. It was quite insightful, and I was very pleased to see that the results of this survey and the observations done by the UNSW team are very similar. So thank you very much for providing me with the opportunity to participate in this symposium, and looking forward to participating in the next session as well. Thanks.
Thank you, Erica, for your wonderful presentation. It really feeds so well into the project, provides a large volume of data and the voices of interpreters. So thank you again. I'm just looking at the time, and we are running behind because the panel was supposed to have started 5 minutes ago. So and I know that some of the panel members joined us specifically for that. So perhaps with apologies to the Q&A to Sandra and to Erica and to Stephen, perhaps we could jump ahead and retain some of the questions that I can see were posted in chat. So I would now like to give the floor to Melanie Schwartz, who is facilitating the panel discussion and who will introduce the topic and our participants. Over to you, Mel.
Thank you. Sorry, I'm mute. Thanks to everyone for such an interesting afternoon, and thank you for staying with us through to the last part of our symposium, our panel. You can see the distinguished panel members who we have up on this slide at the moment. And what I'm going to do is because we don't have a format with Zoom where we can kind of isolate the panel members. So I'm going to ask, just for the time that the panel are speaking, just so that we can maximise the number of panel members that you can see, if I can ask panel members who are comfortable to do so to turn on your video, please. And if everybody else can turn off their video while the panel is speaking, then that will help Zoom to prioritise the view that you have of panel members. So thank you so much for doing that. We've only got an hour. We have a large panel, as you can see, and I imagine that we'll want to hear as much as we can from everybody. But if there are pressing questions, please put them in the chat and I'll see whether we can incorporate them into the discussion. So you'll see before we take down the slide, you'll see that we have 3 categories of participant in the panel. And the panel is really such a great opportunity to pick up and draw together some of the themes that were raised today, and to do it in a way that allows all of the different important players in the courtroom, where there is a bilingual or multilingual courtroom, to sort of be in conversation with each other. So we have 3 judicial officers who are with us today: Her Honour Judge Culver, His Honour Judge Sulio, both from the District Court, and His Honour Magistrate Abdul Karim, who serves in local courts in Sydney's West. We also then have our practitioners. Thank you to Bill Neild and Catherine Jeffries for joining us. One a public defender, Bill, and Catherine, a Crown prosecutor. We have 2 interpreters today, with apologies from Mahbul, who couldn't be with us at the last minute. Cynthia, who is a Spanish to English translator, and Dr. Kenny Wang, who is a Mandarin to English interpreter and translator. And then, of course, we also have Rima Nazha from Multicultural New South Wales, which is one of our partner organisations in our ARC project. So, Julie, could we take down this slide now? And can I ask panel members to turn on their cameras and unmute themselves, actually, if you're able to do that, if the background noise allows you to do that. And as you know, our particular project starts or takes its focus on judicial officers and the way that judicial officers can assist with the way that interpretation occurs in a courtroom, in a criminal courtroom in particular. And so my first question will be for the judicial officers. I'd like to ask, from your view from the bench, what are the biggest issues that you have observed in the treatment of interpreters in the courtroom? And have these issues changed over the years? Who'd like to go first?
I'm happy to, if that suits everyone. And thank you, everyone, for having me. I'm Jane Culver. The first issue I'd like to mention, and I'm sorry if anyone has been discussing this already, because I've only just been able to join the meeting, so I'm sorry to be repetitive if I am. During COVID, of course, there's been a greater need for social distancing in the courtroom, and regularly interpreters who are required in the courtroom to engage in simultaneous interpreting in New South Wales are being required to sit up close to the person with non-English speaking background. And I think that's a difficult health issue for interpreters. Sandra Hale has been assisting us with exploring other measures, and that's underway for New South Wales, and I'm very grateful to Sandra for that assistance. So there are some technological matters to be explored there. Aligned with that is the perennial problem of interpreters who are being asked to engage in simultaneous interpretation, sitting in the dock area, the custody area, and it may be with someone who is being sentenced for really, really serious crimes. And I'm always aware that that's a matter of personal security for an interpreter. And I always ask an interpreter whether he or she is comfortable to do so, because I just think that's got grave issues which can be overcome by these matters of technology that Sandra Hale is assisting us to explore. The other two areas that I just briefly want to mention in terms of issues for the treatment of interpreters in the court are, firstly, I am seeing that more and more interpreters with a great level of training and skill are asking to have some form of briefing or some understanding of the context in which they'll be interpreting. And I think that's perfectly understandable. I often ask, for example, whether an interpreter would like a moment to just speak generally with the person for whom they're providing assistance, just to have that comfort of understanding their respective language skills or accents and so forth. But I'm finding there's a bit of a pushback that often arises if interpreters are asking to have some briefing, because there can be, in criminal proceedings, a great fear that, for example, a complainant will reveal something about the allegations, and that should be the subject of discussion. Or there's a fear that by having the context, there will be certain assumptions made by the interpreter in giving an interpretation. I think many of those concerns are groundless, especially when you're dealing with a highly trained interpreter. And I think that feeds back to Dr. Gonzalez's suggestion, and I imagine other people, I know Sandra Hale has been suggesting that we really look at giving some priority to a very skilled interpreter being utilised in the courtroom. The second and final matter I just wanted to touch on is this problem that is arising in my experience more frequently, and that is where a representative or assistant to a legal team speaks the same language as the person in question, and they raise issue with the quality or accuracy of interpretation, and trial proceedings can very quickly unravel, and it really can become a problem. And I know that the standards have some recognition of that, although there's never one size fits all as to how to resolve that. And I think that is potentially resolved by the focus on really giving priority to very skilled interpreters in the courtroom. I always like to remind the people who complain about that these interpreters are officers of the court. So I don't want to take up the whole meeting, but they are some observations that I'd like to make.
Thank you. That's fascinating, and actually gives us some quite different perspectives or raises different issues than what we've been talking about so far today. Judge Sulio, can I ask you whether you have a different perspective, or whether you would agree that those are the major issues that arise?
I endorse Jane's comments. From my point of view, in relation to the question that you've posed, I pick up Jane's last point, and I think the biggest change that's occurred is the recognition of interpreters as a highly trained profession and as officers of the court who are participants in the process, independent of the parties in the litigation. And I think that's led, and I hope it's led, to a different way of treating interpreters. That is, that they have an obligation to the court, and in turn the court has an obligation to the interpreters to make sure that they are treated respectfully and in a way that makes their task much easier I mean, we've started to develop practices of meeting with the interpreters in the ante room outside court to discuss, at least in brief, the nature of the case and what's going to be required of them, to reinforce that relationship that they are part of the court process, not a visitor hauled into the court to perform a particular task. And that, I think, has been a very significant change, and one that has educated the judiciary about the way that interpreters should be dealt with, but also, I hope, brought to the interpreters greater comfort that they are being looked after by the judicial officers in carrying out their task in the justice process.
Thank you. Your Honour, Abdul Karim, do you have anything further to add?
I agree with what has been said. My only comment is perhaps a practical issue, and it's not, and perhaps a side point. And where I'm working at the moment, there's a lot of people from Middle Eastern background, and you're dealing with a lot of domestic violence matters. And it's important to ensure that the interpreter is of the appropriate gender and appropriate age and appropriate dialect. And I think at a practical level, at times witnesses might not feel very comfortable disclosing what might be personal matters with an interpreter. For example, you might have a female complainant of a certain age speaking with speaking through a male interpreter. I think at a practical level, that is something that I've sort of picked up, and I think the best way to address that is to ensure that when an interpreter is booked, that the judicial officer makes that inquiry. Are there any requirements? I think that's the only additional comment that I would make, or additional comments.
Thank you very much. And I'd like to go now to our interpreters on the panel to ask what their view is, whether their view as an interpreter is different in terms of what the priorities are, or whether that all rings true to you. So we have Cynthia and Kenny. Who would like to go first?
I'm happy to go first.
Thank you.
From my point of view, what makes the courtroom for me a positive or a negative experience always comes down to whether I am able to interpret to the best of my ability and to the standard required. And for me, there are two main factors that will affect my performance. And those are, number one is whether I can hear everything that is happening in the courtroom. And secondly, whether I have a good understanding of what is going to happen in court that day, and I have a good understanding of the matter and a chance to prepare. What I would like to very briefly mention today is that I had an excellent, very pleasant experience at a trial recently in the district court, where all the things that are mentioned in the recommended national standards actually happened. And so I had the barrister and the Crown prosecutor. They briefed me and they provided me with the documents that I needed to do my job, to do all my preparation. I had the hearing loop provided to me every morning by the court officer so that I could hear everything. And the judge, who was sensational, the judge ensured that there was no overlapping speech. She made sure that the barrister and the prosecutor were speaking in short segments so that everything could be interpreted fully and accurately. She gave me a copy of her directions to the jury so that I could follow and everything could be interpreted accurately and fully as well. And very importantly, every morning I was provided with materials that I could prepare for that day. And if I didn't finish preparing when it was about time to start, I would ask for 5 or 10 minutes to finish my preparation, and the judge granted me that time, which meant that the interpreter was fully prepared before she started her job that day. Now, when we talk about preparation, I wanted to say that everything, like I said, everything that is in the recommended national standards actually happened, and everyone followed best practices. And the interpretation means that interpretation could be outstanding, and it benefited absolutely everybody in court. And when we talk about preparation and briefing, what it does is it reduces the knowledge gap between the interpreter who arrives in court with no knowledge of the matter and the other participants who have all the knowledge of the matter. And it ensures that the interpreter can perform at the same level and to the same standard as the other participants in the proceedings. That's all it is. That's the briefing and the preparation, and it is essential. And it makes all the difference between mediocre or poor interpreting, even for experienced interpreters, and excellent interpreting. Now, the other thing that I wanted to mention is that the judicial officers can and should have a very important role in ensuring that this happens. And it has been recommended that they can as easily as say to ask the interpreter whether they have been briefed or not. And if they haven't, just go outside with the solicitor or whoever it is that can brief the interpreter and take a few minutes to be briefed. And it's really as simple as that, very effective, and it makes all the difference. And all of this would ensure that all of us in the courtroom are working together for the benefit of the court and for the benefit of the judicial system.
Thank you very much, Cynthia. And I wanted just to invite Kenny, if you had anything that you'd like to add to that. You've got to unmute.
Yes. So my observation from my experience is that judicial officers in Sydney are quite aware of the needs of interpreters, that they are quite polite and well-mannered towards interpreters. And I have noticed an improvement in the last few years of that happening. Some of the issues that we have covered so far are recurring issues, but I would also like to report that about a year ago, I also came across a matter where there was only one defendant in the local court. And when I arrived at the courtroom, I noticed that there were two interpreters booked. And to my delight and surprise, that the magistrate had decided to book two interpreters so that we could take turns to provide chuchotage for the defendant. That was the only occasion where there were two interpreters booked, and there was a relay or a team interpreting. And so that was a very positive experience. There was also another point mentioned by Erica about perhaps in certain cultures where it's much more hierarchical, interpreters might feel reluctant to perhaps interrupt or ask for repetitions or sort of voice their particular concerns. So I think, yes, it is quite important for judicial officers to sometimes take the initiative to offer that opportunity, or to sometimes even step in and perhaps ask the barrister or the prosecutor to rephrase a very convoluted question, or to make sure that they speak in shorter sentences. If the judicial officers can take the initiative, sometimes that's going to be very helpful to the interpreters.
Thank you. So I might just go back to the judicial officers just quickly. You know, I'm just struck by what Cynthia said about the fact that in her very positive experience, it was an experience where the recommended national standards were being closely adhered to. So I wanted to ask, I might go to you, Judge Sulio, if that's okay. What are your thoughts about our preliminary findings in our research and in other research that we've heard about today, that the recommended national standards are not very well known among the judiciary or not very well adhered to?
Yes, thanks very much, Melanie. First, I'd like to thank Cynthia for her very positive observations about her experience. But my work in speaking to my colleagues indicates that the preliminary findings are in fact accurate. I want to say, to declare a conflict at the outset, I'm very passionate about the topic of interpreters. Both my father and my mother worked as interpreters, including in the courts for many years. So I have some direct experience of their reports on their time in court dating back to the 70s and onwards. And so I can say that firstly, as interpreters, they and their colleagues took their work very, very seriously. And in those times, things were not made very easy for them. The strain on interpreters because of the emotional work that they're involved in is obviously a great one, and that's something that the standards, and I see that Justice Francois Kuntz is in the audience, and he was one of those who instrumental in doing the great work in developing the standards. So I'd like to acknowledge him. But what the situation that's developed, as interpreters will know, is that they often find their way into this work because they're acting initially through some sort of community service involvement. They assist people who are vulnerable. The motivations are very positive, and to see the profession of interpreting develop into such a polished and important role has been very satisfying to me. The standards have set up a framework which firstly instill in the courts the requirement for a respect for the interpreting profession and an acknowledgement of the value of the role of interpreters in the justice system. They obviously require certain actions to be taken, but what they really do is signal a cultural shift in attitude. That takes, as we know, cultural shift in any area of endeavour takes time. And so whilst members of the judiciary are generally aware of the standards, the detail of the standards is not known to them. The implementation of the standards is patchy. I won't go through the detail of it, but courts around the country are in the process of adopting the standards either by way of practice direction or adjustment to rules and so on. And as people may know, the standards have a recommended set of rules of court for implementation. That again is a process that is unfortunately a somewhat gradual process. So I acknowledge the limited adherence to the rules or the standards at the moment, but I want to say that the Judicial Council on Cultural Diversity is in the process of establishing a working group which is developing an education program designed to educate judicial officers, designed to educate the profession and form part of the compulsory professional development units that they'll have to undertake. Designed also, and I pick up a point that was made earlier, I think, by Erica, about the importance of educating students. We're focusing on law students, naturally, but to become part of the curriculum for law students and to become part of the curriculum for the National Judicial Orientation Program, which every new, I won't say young judge, every new judge has to undertake at the start of their career. So the process is an ongoing one. It would be wonderful if the standards were downloaded, read and adopted and put into practice immediately, but it's an ongoing process, and I think it'll require some encouragement, and so that product coming out of the working group from the Judicial Council on Cultural Diversity, I think will be an important step in ensuring a greater uptake, a greater understanding, and then a greater implementation of the standards.
Thank you very much. And that picks up actually some of the comments that were being made in the chat there, particularly from Justice Kuntz around the way that that judicial officers, education is for judicial officers is very important, but the education around these issues needs to go much more broadly than that to all members of the profession and those involved in the courtroom. Our other judicial officers, would you like to add anything to what's been said?
I just like the idea that technology allows us now to have a really standardized education for people. So training modules that you can just look at on your tablet device or laptop, whatever, so that they truly are nationally understood and uniform throughout Australia. I think there's a great opportunity for us.
Yeah, thank you. Okay, so I might bring our lawyers in to the discussion around about now, and I have to apologise, Dee, that I didn't originally introduce you. You're coming to us from the best organisation in the world, from Legal Aid, and you are a Mandarin-speaking legal practitioner. It's lovely to have you. Thank you for joining us. So I'm going to give you the first opportunity to respond to this question, and then go to our other practitioners. And it's really just to ask you from each of your perspectives, from both sides of the bar table, what your view is about the role that practitioners can have in helping to ensure that a courtroom where there are interpreters is one where access to justice is maximised. See.
Hi everyone, thank you, Melanie. So in my role, often we do have lots of clients or witnesses who do come from English, non-English speaking backgrounds, and being a Mandarin speaking background, I do appreciate, even just from my family's perspective, how sometimes, it is really difficult to follow if you lose context or particular words are missed. So when I do work with interpreters, depending on the context, but if it is in court, I do find, and it goes back to briefing interpreters, I do find that it is very helpful in the morning or during the break when before the interpreter is about to come on, that together with the prosecutor, I often just ask and have a discussion with them before we do speak to the interpreter, what the plan is and what we are going to brief them about. So just having a discussion about the key concepts, the ideas, what the witness will be largely be asked about. That context, I think, is really important, because sometimes the nuances in that particular language might be lost, and sometimes a direct translation is not the most accurate translation because the context is lost. So I do find that really helps. The other aspect which I think helps is often in conferences with clients or with other witnesses, it is really helpful with interpreters to just let them know what is expected of them and what they can expect from us. So if I'm speaking too quickly, if I'm speaking with a large chunk, they can ask me to break that down if they don't understand. Sometimes I think that does help interpreters feel a bit more comfortable with raising things, and I think that's very important, particularly with someone who might be a bit more shy or timid. The other thing that I think is important is I often find with interpreters, not often, but sometimes occasionally does come up where they might be asking a clarifying question. And I think it's important that it is recognised that it is a two-person conversation. So if there is a clarifying question to be asked, they should make that clear whether they are clarifying it from the client's perspective or whether they need us to clarify it. So I think that's really important. And also the importance of having breaks. I do appreciate interpreting can be very tiring. So if they do need a break, I think it's important for them to be able to keep up the standard of quality translating and interpreting. If they need a break, they should be comfortable to ask for one. So those are just some of the things I've adopted. But in general, I do find that this standard is very variable. Lots of lawyers don't necessarily implement briefing and all of those practices. I think more education is needed, and that's something I would like to raise with the education section, and perhaps we can have a CLE within legal aid so we can start implementing that better. Thank you.
Great, thank you. Bill, would you like to add to that? We can't hear you. Nope, still can't hear you.
How's that?
Yeah,
how's that? Good. Is that better?
Yeah, got you.
Okay, sorry about that. Yeah, look, I think it has to be an active role if lawyers are going to best assist the court in situations where there is a need for an interpreter. In an ideal situation, you wouldn't be sitting back and waiting until the last minute when the witness and the interpreter, or more commonly in my case as a defence practitioner, your client and the interpreter are getting together for the first time immediately before going into the courtroom. as much as possible, the way in which the court, and it's not just, of course, the person who has triggered the need for the interpreter who is assisted by the use of the interpreter. It's a two-way street. And so in that sense, everyone is far better assisted if thought has been turned at an earlier point in time to assessing accurately the need for an interpreter and giving that interpreter the opportunity to speak, as I say, in my case, generally speaking, to my client as opposed to witnesses, to make sure that they are properly able to understand each other. And in that way, while I guess I've been educated as part of my participation in this symposium by the need to more formally brief an interpreter prior to the commencement of proceedings, there is, by that process of getting the interpreter and the person who has triggered the need for an interpreter together at an earlier point in time, in some ways an informal briefing process that takes place, because by way of taking instructions from your client with the use of an interpreter, you are introducing those concepts to the interpreter, and hopefully any difficulties that there may have been in terms of unfamiliar concepts or names, there's the opportunity to iron a few of those issues out well in advance. That said, when we are in the middle of running trials, there are often many, many moving parts, and we are often not as conscious of the need to do these things as far in advance as we could be, simply by virtue of pressure of time. But I think as people become better educated about the advantages to be obtained from early retention, engagement, and engagement by way of briefing with interpreters, that the process will hopefully run a lot more efficiently and effectively.
Thank you. Catherine, is there anything you wanted to add from the Crown Prosecutor perspective?
Sure. Look, I think the issue of briefing is a really important one, and one that there really is a need for greater awareness about. I think as practitioners, to the extent that I can speak for myself and my colleagues, I think we're aware of things like the need to make sure that interpreters are requested for witnesses or other participants in the court process who need them, and the need to adjust the way we speak in court to allow for the fact that there is an interpreter who has a job to do. But the question of briefing is one that is slightly more novel, and I think there just is not as much awareness about it as there should be, because it obviously is a very important part of the process. And there are certainly practical considerations that come into play. In my experience, when I come to court, I'm going to be calling a witness and there's an interpreter, I don't know who the interpreter is going to be until the day. I don't get to meet them until very shortly before the witness is called. And so while there's an opportunity for a very brief discussion, which is obviously a briefing and it is better than nothing, that seems to be at the moment, certainly in the system that I'm working within, the first opportunity for there to be that kind of discussion. And so there are all sorts of issues there, but certainly the need to have a discussion, make sure that the interpreter is aware of what the issues are going to be, and the nature of the case is something that's very important. And I'd second the suggestion that's been made about having CLEs available for the DPP as well as legal aid, to make sure that everyone is aware that this is a very standard, acceptable thing and an appropriate way to treat professionals who are important participants in the court process.
Thank you very much. And I'd like to pick up on what you've said about the not knowing who the interpreters are until the day, and that sort of process of having the interpreter allocated. And take the opportunity to go to Rima, who is involved with, in an organisation that puts forward the interpreter to the court. And for your reflections, Rima, about the court administration and what what parts of that process, in your view, need improvement, and how responsive the court administration has been to any feedback or complaints around working conditions?
A big question. Because, as you know, we deal with all the courts and tribunals within New South Wales, so they come with their own challenges, and so we have some courts that kind of work very well with us in terms of making sure that the interpreters' requirements are met, especially when they're working on more high-profile cases. But there are other courts that, because of the, I suppose, the volume and the workload that they have, the requirements of the interpreter, unfortunately, is not as a priority. And we try and work with them as much as we can. And usually that comes to our awareness when the interpreter is complaining about that particular court and the officers there. Yeah. But with the intention to make improvements there, obviously. So we have a multitude of layers to deal with the courts and the officers within the courts. Yeah. So yeah.
So if you could choose one thing that might change, you know, the most egregious issue, the most problematic thing, what would it be?
I'd like to choose two. The first one definitely is what everyone has been echoing, is the preparation and the briefing of interpreters. So they need to somehow work with us as the provider and with the interpreter to provide some sort of briefing, whether, you know, that oral briefing or they send through documents or whatever, to be able for us to send that through to the interpreter. The second one for us as a provider more so, and also it impacts on the interpreter, is when, and I'd echo the issue that Her Honour raised, is when the lawyers speak the same language as the interpreter, and sometimes these are big, you know, high-profile matters, or, you know, very sensitive matters that are before the court, and they will stop the whole process because they thought the interpreter, you know, didn't interpret correctly. So that stops the whole process, and then we have to then review the transcription, the court transcription. We have to speak with the officers, we have to speak with the interpreter to make sure, you know, to understand what transpired. And at times it then puts a halt to things, and then trials have to be, we have to restart the trial. So we need to avoid the lawyers that speak the same language need to not interfere with the interpreter's work in court unless there's very obvious inaccuracies. Yeah.
Yes. Okay. Thank you. That's really interesting. So I might go to you, Magistrate Abdul Karim, if that's okay, because one of the things that Rima raised was that different courts are very different, and, you know, the different tiers of the court system will give different results. And I wanted to ask you, as a local court magistrate, whether there were particular issues that you could identify for interpreters in the summary jurisdiction.
Yes, I think the difficulty that the local court faces is that you deal with a large volume of matters, and where I'm sitting in Liverpool, there's generally the one interpreter that at times we have what is called a block booking, where you have in certain languages, and that one interpreter is being asked to jump through 4 separate courts to interpret, and they're put somewhat in a very difficult position because they know nothing about the matter. They have to jump in when there's another court that might be waiting for them. And I think that creates, no doubt, significant pressure on interpreters. Sometimes interpreters will say, look, I need more time, but it's just a matter of having that interpreter saying as much, saying I need time, I don't have, yeah, so I think that is one aspect. And the other point is having sufficient interpreters. Sometimes I've been in hearings when there's multiple persons need interpreters, and when not sufficient interpreters have been booked. Yeah, I think it creates pressure on the interpreter themselves to do something in circumstances when they feel that they're not able to interpret to their best professional ability. Yes, the other aspect, which is somewhat of a side issue, is ensuring that the interpreters are culturally appropriate. I had a situation where an interpreter in the Dinka language was arranged by the court, and the defendant refused the interpreter because they came from different tribes, and the interpreter, unknown to me, came from a tribe which is alleged to have committed significant atrocities against the against the tribe of the defendant. And the defendant was going and taking his shirt off and showing me about all the scars of injuries, and he refused the interpreter. And throughout the proceedings, the defendant had his back to the interpreter. I mean, just this is sort of an example. I don't know if there is a solution unless you know in advance how to. I mean, some of those issues can be resolved if you had better knowledge in advance of the problem arising. Yes.
That's very interesting and difficult. A difficult one.
Would I be able to just quickly ask a question of the interpreters? Just with local court, given the number of self-represented litigants there are, can I ask with the interpreters whether that makes it even harder for them to get a proper briefing about the matter? In summary.
Yes, it is very difficult when you have self-represented clients, even clients who wish to go on to have their matter heard with the assistance of the interpreter, sort of acting, perhaps the client hoping that the interpreter would in some ways help them out. And so that expectation, it's difficult to manage. And when the interpreter does the right thing ethically, then the burden falls on the client to manage that interpreter-mediated hearing on their own. It does create a lot more problems, yes.
Thank you. Thanks.
If I could just add to that, in my experience, what I always do when the defendant is not represented, I always ask them for a copy of the fact sheet. And then I read what is going to happen, and I basically read what the matter is about. That gives me an indication. And the problem usually arises when I ask them what is going to happen in court today, and they really have no understanding of what is going to happen in court today. So they actually are very confused. So I sort of leave it at that and hope for the best, because I don't know what's going to happen in court either that day. But it can be a problem to work with people who are not represented and don't understand how the legal system works or what they are supposed to be doing there.
Thank you. I'm sorry for the interruption.
Not at all. Thank
you.
you.
Can also offer a perspective, just sort of one that touches on multiple fronts. I have noticed that it's much more difficult for non-English speaking clients at the local court to even become aware that they have the ability or the opportunity to speak to legal aid in court. That is the duty solicitors. I guess number one, there is really no multilingual signage to let them know that there is legal aid, that there is duty solicitor available for them to speak to. Number two, I think for English-speaking clients, when they arrive at the court, they can probably go to the information desk and talk to the volunteers there, who will probably direct them to the legal aid office, where they can sign up and wait for their turn to speak to a legal aid solicitor. But that opportunity is, often not there. for the clients to be made aware that there is such a facility available for them. And that sort of ties in with the block booking interpreter as well, because sometimes I might be block booked for Mandarin for the whole day, and there might be 5 clients, 5 short mentions. But one of the clients realizes that they can talk to the legal aid duty solicitor. So I might end up spending, 40 minutes assisting one client, talking to legal aid, and I happen to be the only Mandarin block book interpreter for the whole day. And the other 4 clients would not have to have their matter heard during that period. And so I think that's probably also another aspect to take into account when it comes to booking for interpreters, block booked, and the sharing of an interpreter between the court and legal aid. And there is also, for example, the client not knowing that there is legal aid available. They might wait for their turn to be called. Their matter comes before the court. The court then asks them whether they would like to speak to legal aid. Then the client then said yes. And so something that could have probably be done, they could probably put their name down and start queuing up for the legal aid appointment right at the beginning of the day, would probably be delayed until much later in the day for that to happen. Yes, so that could probably also feed into His Honor Abdul Karim's point about not having enough interpreters booked for one day. Perhaps at the time of booking the interpreter, it was probably thought that one interpreter was sufficient, but perhaps not taking into account the legal aid aspect of it.
Thank you. Thanks, Kenny. And that actually touches on just the last question that I wanted, the last formal question that I wanted to ask, which is also to our interpreters, just to sort of pick up on this idea that you've already raised about the courtroom as a workplace. So the courtroom is a workplace, pretty much for everybody on the panel. But I just wanted to ask the interpreters, particularly, what is the biggest challenge? What the hardest thing about having the courtroom as your workplace?
For me, the biggest challenge is that I am there to work, but no one has made any provisions for me to work there. So I come and there's a physical presence of the interpreter because the interpreter has been booked, but that's all that's been done. So the interpreter is usually not provided with anything else that they require. Nobody has looked into the hearing needs, whether they need to be, they need the equipment, or whether they need to be sitting on a comfortable chair, or whether they're going to be sitting inside the dock or interpreting from outside the dock, because in many courts, local courts, you're not allowed inside the dock. So you have to interpret from outside, leaning like this for hours on end. Nothing like that has gone into, there hasn't been any thought processes about what the interpreter needs. One of the main things that I find when I go to court is the uncertainty. I don't know whether anybody's going to agree to brief me or they're going to refuse to brief me. So it is the uncertainty, and on my way to work every day, I'm thinking, what arguments am I going to use today if they push back when I ask for something? And I think, because when I need to ask for things, and I am not shy about asking, very often they will just say no for all sorts of reasons. And each person will have a different reason. And there is that variation between each person that you're always dependent on the individual solicitor or the individual prosecutor or the individual magistrate, and you don't know in advance what that particular individual is going to say to your request. There's no standard provision for the interpreters whatsoever.
Very much. Rima, did you want to add?
Oh no, not sorry.
No, sorry, you just popped up for me.
Sorry.
Kenny.
Yes, the issue of chuchotage, so whisper interpreting for the client has been mentioned several times. There was an occasion where it was a sentencing matter, and there were 3 co-accused, and there were 3 interpreters booked. And so 3 clients and 3 interpreters, or 6 people sitting in the dock and whisper interpreting for our respective clients. And it was very, very challenging, very difficult matter. And understandably, each defendant was very anxious to find out what their sentence was. But with people sort of talking over each other, it was very difficult for me to, when it comes to the crunch, trying to hear the sentencing for my client. So that's one experience. Personally, I find that I don't really mind going into the dock and sitting next to the accused person to shushtash for them, because in my experience, they're always very courteous to me because they understand that I'm there to help them. I do remember very vividly, though, that there was one occasion where I really had reservations about going to the dock to sit next to the client, because the client was obviously visibly mentally disturbed. He was, mumbling to himself. And so I remember on that one occasion, I just thought to myself, there could be uncertainties. The client could be, it's a bit hard to predict what the client might or might not do. And so that was one other experience of mine about shushtash.
Thank you.
Kenny, Melanie, can I just jump in and say that I recently had a matter, Kenny, where there were 2 accused, one who needed a Mandarin interpreter and one who needed a Cantonese interpreter. And by some bureaucratic maladministration, we managed to get an interpreter who spoke both languages, and he sat in the middle and had to turn left and right to perform shushtash in 2 different languages. That was very challenging, I think.
Amazing. Interpreters as superheroes. Okay, well, thank you so much. We have just 2 or 3 minutes left still in time. So I just wanted to open it to the panel in general to ask whether anyone had anything that they'd like to cover that we haven't yet chatted about today. Anyone would like to say anything in closing?
I have also a request, if it's possible, to His Honour Abdul Karim, if we can reach out to all local court magistrates and have some dialogue about a number of issues, and how do we do that?
The best way.
Can you help us lead that, or are you a contact person, or?
The short answer is I'm not a contact person. The best way to do it is to arrange it through the Chief Magistrate's office. The difficulty is the local court, the court sits in so many different areas, and bookings of interpreters is, falls to a large extent on registry staff rather than magistrates individually. So the best way to coordinate that is through the Chief Magistrate's office. Because I think if a lot of the issues, at least from my experience, a lot of the issues, if they are identified at an early stage, they will never arise. They only become issues because they were not identified at an early stage. I'm not trying to attribute whose fault it is. I'm not trying to attribute any fault, in fact. But what is important is if you're able to identify those issues. For example, if an interpreter has been used by a police officer, and that's one other point that I wanted to raise. I had a situation where an interpreter was used by the police during to interpret during a record of interview, and it's that same interpreter has been arranged by the court. I wondered to myself whether the defendant thought that there was some greater conspiracy, that the courts are working with the police, and just identifying issues like that when there is no, that the interpreter is seen by all persons involved in the process to be providing a professional service.
Thank you. Well, can I please thank everybody on our panel for giving your time and your expertise to in being with us today. I have seen both in the chat and amongst panel members light bulbs going on through our discussion about things that might be done in each of our organisations to progress some of the issues that have been raised, and that's really encouraging. That's exactly the type of thing that that we would hope to happen out of a forum like today. So big hopes that some of those things will come to fruition, and that particularly some collaborations that have been suggested, that they can come to fruition as well. So I'm going to hand back to Ludmila now to close our symposium, and just thank you again to all of our panel members for joining us today. Thank you.
Thank you.
And yeah, and Melanie, let us all thank you and all the members of the panel for a very enlightening discussion. Again, there is never enough time, but so many important issues were raised, and we hope to be able to continue. And now, in the remaining time, I would like to invite Sandra Hale to present her conclusion and recommendations before we close the symposium.
Thank you. If I can share. So while everybody was speaking, I was writing, trying to come up with a summary, and thank you everybody for your wonderful contributions. Can you all see that? Yeah? Okay. So I've got, Ludmila, can you see the screen? Yeah. So I ordered the recommendations from what we heard throughout the symposium in order of my perceived order of difficulty. I'm probably going to be told that I'm too ambitious or too unrealistic. But the first ones that I think are a low level of difficulty, so the ones that could pretty much be implemented straight away. So I think number one, we've already heard from the JCCD that there will be an active campaign to disseminate the recommended national standards and raise awareness among all court participants. But I think that's something that we could all take on in our various organisations. So I think that's probably the easiest one to do. The next one, which is related to that, that court participants treat interpreters with respect as officers of the court. So that's something that needs to be highlighted, that interpreters are part of the court, that they're not the other, that they should be respected as such. And that's obviously part of the education and dissemination campaign. Some of the interpreters said that the judicial officers should be a bit more proactive in helping interpreters in court in terms of offering them the breaks, asking the lawyers to rephrase, which we know that a lot of judicial officers do this, but something that should be more widespread. Provide at least oral briefings. So if the interpreter comes to court and the judicial officer could be proactive and ask the interpreter, have you been briefed? And if the interpreter says no, then give the, as Cynthia said that happened to her, give the interpreter and the lawyer, whoever it is, the prosecutor, a bit of time, adjourn for a few minutes to brief the interpreter. That will be better than nothing. Again, breaks, giving the interpreter the written materials that will be presented so that to be side translated so that the interpreter doesn't have to listen to someone read. Give the interpreter the hearing loop like they would to a person who's hard of hearing in order for them to at least hear properly when they have to interpret simultaneously, even if they have to sit next to the person. I think it would be easy to offer the interpreters a room in each court. I go to court and I see a lot of empty rooms, even an interview room with a sign on the door saying interpreters room, and then everybody would know where to find the interpreters. And that would someone muted me. So they could go to the room and brief the interpreters. Provide a workstation or a desk in the court for interpreters. And again, they could have a sign saying interpreter's desk, and the interpreter could work from there and use the court's technology. The issue about recruiting in terms of appropriate gender and cultural background for certain cases, such as domestic violence, that's something in the recruitment process. Compulsory training on working with interpreters for law students, practicing lawyers, and other court participants. And the South Australian model of setting up regular meetings with language service providers, interpreters, and courts to discuss issues that I think, that would raise a lot of awareness and create a sense of teamwork so that everybody knows what is needed. So that's the low difficulty. These are the middle difficulty. Devise a system whereby interpreters can be provided with relevant case-related materials in advance when booked. And some type of portal on the internet could be used, or simply the way that now the defense and the prosecutor share the briefs, maybe the interpreter could be included in that as well. But obviously that requires proper recruitment practices so that interpreters are recruited well in advance and they are considered to be part of the team. The portable simultaneous interpreting equipment is something that can be easily implemented in all courts. It's not very expensive, and that's something that we're talking about at the moment. And that would avoid the need for the interpreter to sit next to the person when they're doing simultaneous interpreting in a chuchotage way. The remote simultaneous equipment for defendants who are in custody, because currently the interpreter cannot do any interpreting. So this can be done with equipment such as computers and Teams if the proper interpreting platforms are too expensive. Two interpreters to work as a team for trials, that really needs to be implemented. And that will remove the problem of fatigue, the problem of making mistakes, of bias, if they're worried about interpreters being biased, if they know what the case is about. The two interpreters, which happens in international settings, this is the standard practice, will help each other. It will go towards the accuracy, will help each other, and they will monitor each other as well. So they'll pick up on any issues, any mistakes, and so on. So it will increase the accuracy and the efficacy. And if there is a challenge to the interpreter's interpreting accuracy, then the other team member, the other interpreter, can comment on it rather than some person who's not qualified to comment, which is the next one, devising protocols for resolving disputes regarding the quality of interpreting when challenged in court. And this will go a long way in avoiding that altogether. Duty interpreters in court with high volumes of non-English speakers of certain languages. We currently have block bookings, but as Kenny said, one interpreter is often not enough. So at least two interpreters for each of the languages. And that's also something that needs to be looked at in terms of efficiencies in recruitment. And the high level difficulty recommendations, I really think that we should aim for adequate simultaneous interpreting equipment, such as the equipment that is used in international courts, in trial courts, even if it is one trial court per city or per state, where the big trials can be conducted with adequate interpreting equipment. Adequate remuneration, again, that's a difficult one, and adequate recruitment and employment practices. And I just have a few photos to show you here to give you an example. So this is the current situation where interpreters sit or stand next to the accused or the defendant. This is something that we did in one of our research projects, where this is what I mean when I say provide a desk for the interpreter. The interpreter is here with the portable radio equipment, listening to the expert witness giving evidence and interpreting simultaneously into this microphone. The defendant is sitting somewhere in the back of the court, so away from the interpreter, but being able to hear the interpretation. And this is the ideal setup with the interpreting booths in a trial. So I'll stop sharing. That's all I've got. If I've forgotten anything, we can add it later. Thank you.
Well, thank you, Sandra. A great summary and a way forward. I think one of the very useful outcomes of this current project that we are working on is that we managed to establish already at this stage a network of stakeholders who share our interest and who certainly will be interested in furthering all these points that have been raised during this discussion. So I would like to finish by thanking all our presenters, the panel members, the moderators, and of course, all the audience who have contributed excellent questions and comments. And my only regret is that we could not give everyone enough time in order to ask questions and have a longer discussion. So maybe next time we should have a longer symposium. So we hope to keep you to stay in touch and keep updating everyone interested in the progress of our research project. And please reach out to us. We will be very interested to work together with all the participants. And many thanks again to our research team and symposium organizers.